All rise.
Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is case Ksc BC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
Thank you, Madam Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Good afternoon, Your Honor. Today, the Specialist Prosecutor's Office is represented by Mr. Alan Tiger, Senior Prosecutor, Nathan Quick, Associate Team Leader, Nada Keswanson, Associate Legal Officer, and I am Wart Ferdinandersen, Head of Prosecution's Investigations.
Thank you, Mr. Prosecutor. Now let me turn to the defense. Mr. Kihu, please.
Good afternoon, Your Honor. Gregory Kehoe, Peter McCloskey, Sophie Maganon, Bonnie Johnson, and in the back we have Chiara Locero and Haneen Ghali on behalf of President Thaci. Thank you.
Thank you, Mr. Kihu. Mr. Emerson, please.
Good afternoon, Your Honor. On behalf of Mr. Vasili, present in court today is Mizania Riley, co-counsel, Mr. Semir Salih, a legal assistant, Anouk Julian, our case manager, who is deputing for our case manager today, and appearing in court for the first time, Thomas Moreno Ocampo, one of our interns. Appearing via video link is obviously myself and co-counsel Mr. Andrew Strong, who may be in a position to deal in more detail with some of the issues.
Thank you, Mr. Emerson. Mr. Roberts, please.
Good afternoon, Your Honor. Jeffrey Roberts on behalf of Mr. Salimi in the courtroom, together today with Mr. Eric Tully, our legal officer, Ms. Natasha Rozhenko, our case manager, and Ms. Sarah Sufi, our intern. I would just also like to take the opportunity to seek leave for Mr. Tully to make submissions today on behalf of the Salimi defense. Thank you.
This is noted. Thank you, Mr. Roberts. And now I turn to Ms. Alejandra, please.
Thank you.
Sorry, Mr. Bayezu.
Yes, thank you, Your Honor. Good afternoon to you and to everyone in the courtroom. I'm Victor Bayeshu for Mr. Jakub Krasniqi. By video link, we have lead counsel Ms. Venkateshwari Alejandra, co-counsel Mr. Aidan Ellis, and Mr. Mentor Bechiri, legal assistant. And I'm assisted today in the courtroom by Ms. Kalina Tsvitkova, our case manager, and Ms. Laura Abia, our support team member. Thank you.
If I may, Your Honor, I neglected to identify three of my colleagues that are on the video. My co-counsel, Mr. Luka Misitic, Dosted Palaska, and Jonathan Greenblatt. My apologies to the court for omitting them.
Thank you, Mr. Kiu. This is noted. Let me turn to the counsel for victims. Mr. Laws, please.
Good afternoon to Your Honor and to everyone. Simon Laws, assigned counsel for the victims in this case.
Thank you, Mr. Laws. And finally, let me turn to the registry. Mr. Nielsen, please.
Good afternoon. Good afternoon, Your Honor, and good afternoon to colleagues. Jonas Nilsson, representing registry today.
Thank you, Mr. Nielsen. And for the record, I note that Mr. Thaci, Mr. Selimi, and Mr. Krasniqi have waived their right to attend the hearing in person, but are attending via video conference. And I also note that Mr. Vasili has waived his right to attend this hearing. And I am Nicholas Guillou, pretrial judge for this case. On 16 February 2022, at the request of the Thaci defense, I scheduled this hearing to hear submissions on the issues raised by the SPO proposed protocol on handling confidential information and contacts with witnesses of the opposing party during investigations. The purpose of the hearing today is to give an opportunity to the parties and participants to debate on the SPO initial and amended proposal. I invite the parties not to repeat their written submissions, but to focus on the specific questions that are included in the scheduling order, to the extent that these questions apply to each party and participant individually. I would especially like the parties and participants to focus on the following questions. What would be the legal basis for the SPO proposal? Would such a protocol infringe on the accused's rights, noting that similar protocols have been adopted in other international tribunals? If the proposal would be considered, should it apply to all witnesses or only to a specific category of witnesses? And could the model developed at the ICC regarding the matters under consideration, or another particular model developed at another international or internationalized court, be applied at the specialist chambers? Finally, I invite the parties to indicate if inter partes discussions could be useful to reach an agreement on certain aspects of the proposed protocol, and if so, what issues in particular. As indicated in the scheduling order, each party and participant will be afforded 15 minutes to provide its submissions, excluding the time required to answer any of my additional questions. Before giving the floor to the parties and participants, I first note that the defense for Mr. Thaci requests that the Victims' Counsel's response to the registry's submissions be struck from the record. I will therefore give a brief opportunity to the Victims' Counsel to provide any submissions in relation to this request, separate from the matters on the agenda for today's hearing. And I will also give the floor to the defense for Mr. Thaci, who may address any new matters raised by the Victims' Counsel without repeating any submissions already made in the request. So first, Mr. Laws, would you like to make any submissions in that regard? Really focusing on the request from the Thaci defense, not on the merits of the discussion of today. Thank you.
Your Honour, yes, I would. Thank you for the invitation. May I start in this way? We don't accept at all what's said in the Thaci filing. I'm happy to deal with it in any way that Your Honour sees fit. I'm happy to deal with it extensively in oral argument today, or to set out briefly headlines in response to it, and then, if Your Honour so wishes, to file a written reply. So we're in Your Honour's hands. I'm conscious that it's not a particularly productive use of the court's time for us to spend a great deal this afternoon on it, because in a couple of hours' time, it's going to be, we suspect, somewhat moot, to put it mildly, because we're going to traverse all the ground that's in the filing that's objected to by the Thaci defence, and if I deal with it orally, I'll adopt what's said in my written submissions and not take up the court's time in that way. But here we go. Perhaps if I just give Your Honour the headline.
Let's proceed like that. Just give the headlines as you proposed, rather than the whole entirety of the submissions.
Thank you very much. The argument put forward by the Thaci defence depends on two submissions. They assert that it is a reply, the document that we filed. Therefore, the argument goes, the word limit has been exceeded and also it's too late. What we say about that is that it's with respect not for the Thaci defence to attach whatever label they wish to a filing. Your Honour's decision on the 21st of January was that responses should be filed, not replies. Your Honour gave us 10 days in which to do it, which is the time limit for responses, not for replies. And the Thaci defence has treated other filings as responses, notably the SPOs. So it was a response, therefore it's within the time limit, it's within the word limit. Their second argument is that, in effect, we went beyond the scope of the invitation to provide written submissions. They don't address the very purpose of the filing that is set out at paragraph 1, namely that Your Honour announced that you were to make a decision as to whether or not there should be an oral hearing. Now, I confess that I'd rather assumed that there would be, but at the status conference on the 4th of February, Your Honour indicated that that was a decision you still had to make. Ordinarily, we submit the parties are allowed to make submissions in respect of pending judicial decisions, particularly where they are as important as this, because, and this is the headline, no one had drawn attention to the ICC's own protocol. And without repeating what I said in my filing, the position was that the SPO's proposed framework was being represented as some very burdensome, very novel and very extreme regime that was going to be imposed on the parties in this case, and it's nothing of the kind. It reflects the ICC protocol quite closely. And so, but by the time we got to the stage of the 4th of February, no one had drawn that to Your Honour's attention. And we submit that that was potentially, at least, a very unfortunate gap in the material before the court, because it may very well be that it was a protocol with which Your Honour was fully familiar and ready to make precisely the points that we made in our filings. But it's dangerous to take to make such a conclusion without a proper basis. So in those circumstances, we felt it was not only open to us to assist Your Honour with that additional information so that you're better placed to take a decision as to whether the hearing should be oral or further written submissions. Not only was it open to us, but it was our duty to do so. If the court had reached a conclusion on the papers without considering the protocol from the ICC, that would have been a very unfortunate outcome indeed. As it is, we're pleased to see that it's on the agenda and quite prominently today, as it should be. So that's what we say in outline, Your Honour. And as I say, I'm conscious that this is going to become academic in the course of the afternoon, but I'm at Your Honour's disposal as to how we deal with it further, if necessary to do so.
Thank you, Mr. Laws. Mr. Kihu, would you like to specifically address any new matters raised by the Victims' Council?
Yes, Your Honour. I believe counsel misperceives what our filing was about. Your Honour invited counsel, as well as the SPO, to comment on the registrar's submission. And Your Honour did that in our last status conference on 4 February of 2022. Victims' Council elected not to do that. He elected to criticize our filing of the 15th of December. And any such filing answering that is well out of time, months out of time, almost 2 months out of time. And they did not answer what the registrar was putting before this chamber. So our criticism was that they went well beyond what Your Honor asked them to do, which was an answer to the registrar's submission. And number two, they failed to do it in a timely fashion. And number three, what they did is use it as an opportunity to criticize our submissions of December of 2021. And it was on that basis that we moved to strike their submissions. Thank you.
Thank you, Mr. Kihu. Let's now move back to our agenda. I will first give the floor to the SPO, followed by the representative for victims, and then followed by the defense and the registry. I remind the parties and participants to give prior notice should any submission require the disclosure of any confidential information, so that appropriate measures may be taken as usual. Mr. Prosecutor, you have the floor for 15 minutes, please.
Thank you, Your Honour. The SPO has submitted a proposal for a framework on the handling of confidential information and contacts with witnesses of the opposing party. And as Victims' Council has just said, nothing in this proposed framework is new or out of the ordinary. The framework has been drafted on the basis of similar frameworks applied in another case before this court and in multiple cases before the ICC and other international tribunals. every single provision of the proposed framework has been enacted before, either in this court or in the ICC or in other international tribunals, and often in multiple. And that background is important for many of the questions to be addressed today. We are not discussing novel ideas of the SPO here. Multiple judges from different courts have considered how to balance the interests at stake, and they have found rules such as these to be necessary and reasonable. At the same time, the challenges faced in this court when it comes to safeguarding witness welfare and security, as well as the integrity of the evidence, are unique. This court exists to bring justice to victims in the context of a long-standing climate of intimidation that has too often stymied justice for more than 20 years. And every single day, many diligent staff in all organs of this court are working toward that goal. To indeed do justice to the victims, we have to learn from the past. And that past has shown that trials against defendants accused of crimes committed while they were KLA members, even those not from the upper echelons of power, were characterized by an extraordinary level of stress and fear in witnesses, and that many such witnesses either refused to testify or changed their accounts on the stand. As we have outlined in earlier pleadings, this was not sporadic or random. It was consistent and predictable, and the consequent need to preserve the integrity of evidence applies here, in this case, indeed with even greater force. We will once again see witnesses too afraid to testify, and we will see witnesses changing their accounts out of either fear or loyalty to the defendants. There is and there will be enormous pressure on many witnesses in this case. The proposed framework is necessary both to allow as many witnesses as possible to give their evidence without fear, and to enable the court to determine where the truth lies when witness testimony will depart from previous accounts, and the question arises how that change came about. Having an accessible record for pre-trial contacts and having two parties able to make submission on those contacts in an informed manner will greatly increase the chance of establishing the truth and doing so efficiently. Thus, to answer your first question, Your Honor, the proposed framework can be ordered pursuant to the following provisions of the law and the rules. Article 23 and Rule 80 for the protection of victims and witnesses. Article 39, 1, 3, 11 and 13 concerning the expeditiousness and fairness of the proceedings and the integrity of the evidence. And Rules 82 and 83 for the protection of confidential information. And obviously, the application of Rule 80 is not time-barred in this case, only because previously a deadline was imposed in the specific context of disclosure. Your second question, Your Honor, asks whether the framework should apply to all witnesses or can be differentiated. The framework does not solely concern the SPO's witnesses, but is formulated to apply equally to all sides. It should apply to all witnesses, since it serves the different purposes I have just mentioned, and some of those, in particular the need to protect the integrity of the evidence and guard against allegations of interference that will otherwise taint this case, apply across the board to all categories of witnesses. And it must be emphasized that there is not necessarily a correlation between protective measures and pressure on witnesses. Some witnesses without protective measures are likely to be severely pressured. Your third question, Your Honor, concerns our reaction to the fair trial arguments of the defense teams. And the SPO's reaction can be as brief as the arguments have been made. The defense has brought forward only general assertions. They have not cited a single relevant case or other legal source to support their submissions. The arguments made by the defense have been repeatedly raised and dismissed at the ICC, where protocols similar to the one proposed here have been adopted. Internal work product protections, or attorney-client privilege, or the right against self-incrimination do not apply when the defense is voluntarily disclosing information to a third party, such as a witness or a potential witness. Interviewing a witness in the presence of another party does not mean sharing your strategy. It means you make smart decisions, what to ask and how to do that. It is done by counsel every single working day all over the world. The right to examine witnesses does not include a right to interview the opposing party's witnesses without oversight or regulation. Defendants have the right to examine witnesses of some importance once in the courtroom and not twice, including an ex parte trial run. Effective preparation for examination in the courtroom can take many forms, certainly for witnesses who have given elaborate statements or been examined multiple times already, as many witnesses in this case have. In the Halilovic case at the ICTY, the pre-trial chamber declined to allow the defense to summons prosecution witnesses because the defense would have an opportunity to question them at trial. In the Dindilimana and Nzirorera cases at the Rwanda tribunal, that tribunal determined that pre-trial interviews were to take place in the presence of the calling party to curtail possible allegations of tampering with the witness and to protect the integrity of the process. In the Lubanga and Bemba cases, the ICC ruled that the calling party would be allowed to attend pre-trial interviews by the opposing party unless an exception to that rule was ordered by the chamber. All of those decisions by all of those courts could not have been taken if the defense had the unfettered right to ex parte pre-trial interviews with prosecution witnesses that is being pursued here today. And I will be happy to give you more details, such as date and paragraphs on all of those decisions, if that is helpful. And the same is true for the many national legal systems in which further witness interviews do not take place at all, once witnesses have been identified for examination at trial, unless ordered by the court. These national systems do not all violate the right to a fair trial on a massive scale. The judges in this court, who have previously drafted and adopted an equivalent protocol, are well aware what the right to a fair trial entails, and they did not violate it in their case. And while the logistical implications in this case are different, due to the number of witnesses, the different rights to be balanced are the same. While your fourth question about joint interviews is addressed to the defense, the SPO submits that the defense team should be encouraged to conduct joint interviews, and in the case of victim witnesses, should be obliged to do so. For all witnesses, it is trying and inefficient to be interviewed more times than necessary. For victims, it is even more stressful and can be severely re-traumatizing. Your fifth and sixth question were not addressed at the SPO. Your seventh question concerns the model at the ICC or a model from any other tribunal. The proposed protocol is similar or even identical in many respects to protocols adopted before the ICC. Based on the particular circumstances before this court, and in this case, in particular, the persistent pattern of recantations in cases involving KLA members, the climate of intimidation, and the unique pressure that witnesses will feel when contacted by the defense in this case, certain amendments were necessary to ensure the integrity of the evidence and to protect witnesses and victims. The SPO's position is therefore that while the models at other courts may provide guidance, the proposed protocol is necessary and tailored to the particular circumstances of this court and this case. The extraordinary pressure and risks in this case have been objectively found to exist. The court has already authorized standard redactions for contact information of witnesses and identifying and contact information of individuals at risk of being associated with this court because they are extremely vulnerable. Such individuals cannot genuinely consent or refuse when asked whether they want to be interviewed or want others to be present when approached for a pre-trial interview. Certainly not when some of them will likely be approached by former superiors, such as the ex-Minister of Justice, who has apparently joined the Thaci defense team. And without a robust contact protocol, the very rationale behind the redactions aimed to protect would be undermined. Your eighth and final question concerns possible inter partes discussions. Within the framework of the proposed protocol, the process is primarily inter partes. The SPO considers that it is better that the framework is now adopted and the parties then consult as necessary and appropriate within that framework. We know that defense teams are already reaching out to prosecution witnesses, and we therefore respectfully ask you to order the framework as proposed, to specify that the framework also applies to contacts that have already been initiated, to order the defense teams to report which prosecution witnesses they have contacted and interviewed before the framework was ordered, and to disclose any available records and recordings of those contacts and interviews. In the alternative, if you decide that inter partes discussions should be held, we ask you to order that contacts with witnesses of the opposing party can no longer take place until you have decided. I come to my last points. Several defense teams, including that of Mr. Thaci, have referred to the Code of Conduct to argue that the proposed protocol is unnecessary. That argument fails. We cannot turn a blind eye to the reality we see in this courtroom every single time we convene. The Ksc Code of Conduct requires counsel to refrain from making false or defamatory statements, to act with dignity and integrity, with respect towards anyone with a standing in the proceedings, and in compliance with any decision or order of the panel. The record clearly shows that the Thaci and Thaci defense teams fail to adhere to these standards on a continuing basis. Even when making their submissions on this very topic, the Thaci team continues its efforts to mislead. In paragraph 14 of yesterday's Thaci filing, lead counsel for Thaci submits that his team is not aware of complaints from SPO witnesses about their experiences during defense interviews in the last 15 months. 15 months would bring us back to December 2020. Let that sink in and think back to all the status conferences we have had last year. On 16 February 2021, counsel for Thaci put to the court, "I haven't started investigations. I repeat that, I haven't started investigations. I can't see investigations starting much before April." On the 24th of March 2021, Mr. Prosper told us in this courtroom that the Thaci team was not in a position to begin defense investigations in April, and elaborately explained why that was the case. On 19 May 2021, Mr. Prosper informed the court that the Thaci defense team was unable to provide clarity on the status of the defense investigation for the foreseeable future, until they received more information from the prosecution. On 14 September 2021, Mr. Kiu told you, Your Honor, and I will quote, "I can't give Your Honor any estimate as to when any investigation is going to take place." That was a little more than 5 months ago. So which one is it? It can't both be true. The 15 months between December 2020 and today do include the months of February and March and May and September of 2021. And behind this looms a graver question. Are we honestly supposed to believe that such counsel will scrupulously adhere to the Code of Conduct in unrecorded contacts with witnesses while nobody else is there? That is not a serious proposition given their behavior to date.
Please conclude, Mr. Prosecutor. We're nearly at 15 minutes, and I have 2 questions for you after that.
I will come to a conclusion, Your Honor. It needs to be stressed that our requests are extremely limited in their breadth. They apply solely to witnesses of the opposing party. The only professional standards and information requests to be imposed on the defense concern their contacts with witnesses for the prosecution. Everything else in the defense investigations can remain the black box that it is. There are many thousands of potential defense witnesses that can be interviewed without the SPO being present or the defense disclosing their records of those interviews if they do not call them at trial. All we ask here is a ray of sunlight on our own witnesses, offering to apply the exact same standards ourselves when we will learn who the defense witnesses will be. In the Haradinaj case, the appeals chamber of the ICTY not only expressed its concern over the unprecedented atmosphere of widespread and serious witness intimidation that surrounded that trial, but also emphasized that for an international court to function effectively, its judicial organs must counter witness intimidation by taking all measures that are reasonably open to them, both at the request of the parties and proprio motu. Multiple judges at the ICC and at other tribunals have deemed the standards proposed here to be reasonably open to them, and so have other judges in this court. And we ask you to follow their example and order this framework now before it is too late.
Thank you, Mr. Prosecutor. I have 2 questions that relate to the difference between your proposal and let's call it the ICC protocol, the one that is attached to the Chamber's Manual of the ICC. The first one is the question of the presence of a representative of the calling party, especially in the case where it is against the express wish of the witness. Your proposal here differs from the ICC standard protocol. What would be the justification?
Your Honor, we have looked at many different protocols, and we note that the ICC has applied different models. So when we look at different protocols, there is not one case where the proposal that is on the table here is deemed to be in violation of the right to a fair trial. As we have said, we believe the justification for the model that is now on the table is in the particular circumstances of this court and in the particular circumstances of this case, especially the enormous pressure that will be on the witnesses. We note that other protocols have a variety of factors to be considered, including the way the witness is contacted, the way the interview is recorded, and where the way the protocol deals with the presence of the calling party. There are models where that presence is given as right. There are models where that presence is based on witness consent. And there are numerous models where there is an exception possible to be made by the chamber. And we believe that, especially given the enormous pressure, as I have specified, the model on the table is the model that should be applied in this court and certainly in this case.
Follow-up question here. Do you think this should be a decision of the SPO then, or this should be a decision of the panel?
The presence of the calling party?
When the witness doesn't request it or opposes it?
Our position is that the presence of the opposing party, like has been the case in other tribunals, is given as of right, with only the possibility of the chamber making an exception.
Thank you. This is noted. And my second question relates to the distinction between confidential information and confidential document. Because as you have seen from the defense submissions, the defense argues that there should be a distinction between the two. The ICC protocol stipulates that confidential information does not include information which has otherwise legitimately been made public, even if contained in a confidential document. And here again, there is a discrepancy between your proposal and the model of the ICC Chambers Manual. Why have you proposed this different model here?
If you allow me, that would be an answer that I would like to quickly look into and give you after some consideration.
Absolutely. Thank you, Mr. Prosecutor. Now let me turn to the Counsel for Victims. Mr. Laws, you have 15 minutes maximum.
Well, thank you. So far as question 1 is concerned, really a matter for the SPO, we make no submissions about it. So far as question 2 is concerned, the answer that we give to the question, should the proposals apply to all witnesses, is yes. Obviously, we only represent those who are dual status, but as a general proposition, we would say yes, the protocol should apply as it does elsewhere. A protocol of this kind promotes transparency in the proceedings, it promotes certainty as to what was said, and it avoids misunderstandings or even allegations being made in one direction or another. And it applies, as a friend for the SPO has just said, to both sides equally. So we answer the first part of question 2, yes, all witnesses. Our specific arrangements required for dual status witnesses is the second part of question 2. And again, we answer that yes, some special arrangements are required. We're going to point to 2 such special arrangements, if we may. The giving of notice to the other side or to victims' counsel. The Thaci defence say you don't need to have a provision governing their contact with dual status witnesses because the Code of Conduct prevents them doing so without informing victims' counsel. And that is correct. And so the response that we would give to that is, if it's something that's already in place, what can the objection be to it being included in the framework? This is not an additional obligation on them. It's one that they must already abide by. And a framework of this kind is going to be much more effective, isn't it, if it gathers together all the different ways that all of our conduct will be regulated, rather than saying, well, we can omit this provision because you can find it elsewhere in a different code of conduct. That, with respect, that seems to us to defeat the purpose of a framework, which is that it provides you with the framework, not that it provides you with part of the framework, and then you can look up the other bits elsewhere when you have time. So we suggest that it's much more sensible for the framework to have, as it were, a comprehensive remit rather than to pick and choose. And it's right to say that the ICC has a very similar provision governing contact with other people's clients in Article 28. It doesn't mean that the ICC has done away with the need for notice. So we suggest that the First Amendment, so far as dual status witnesses are concerned, is that there should be indeed notice to victims' counsel and the SPO, whose witnesses that they are. The second suggestion that we make is in our filing at paragraph 17. I'm not going to repeat it in detail, but just as a headline, as it is an answer to the second question. If required by the witness, victims' counsel should be permitted to be present at the interview. And we refer to the Al Hassan case at the ICC, where it was said that dual status witnesses are entitled to have their legal representatives attend interviews should they so decide. And so we would say that that is an additional requirement for dual status witnesses, bringing me to the end of what I want to say about question 2, part 2. For question 3, I hope, being loyal to Your Honour's direction, what I said earlier, I've set out already in writing my submissions in relation to whether or not the fair trial rights of the accused are jeopardised, and I'm not going to repeat them at all, but I stand by them. Question 4. May we adopt what's just been said by the SPO? It's not obviously a question directed at us, but do the defence teams intend to organise joint interviews of witnesses? They must do so where they are planning to interview witnesses who are also victims in the proceedings, or any other vulnerable category of witness. There simply can't arise a situation in which a witness gets interviewed 4 times by the defence. It would need, we respectfully submit, some very exceptional circumstance to justify a second interview, and that's something which perhaps should have oversight from the panel. So, question 5 is directed to the registry, and I shan't take up any time in relation to it. Question 6, what's the position of the defence teams and of Victims' Counsel in relation to the adjusted SPO protocol? What we say about that is this: we don't object to the amendments that have been put forward by the SPO in response to the registry. We can see the practical difficulties, of course, for the registry in fulfilling the obligations as they were initially set out in the SPO's proposed framework. We suggest that the protocol should, however, be flexible as to the presence of the registry in exceptional circumstances. We would encourage, Your Honour, to leave an element of discretion there. It's sensible perhaps to say that the decision should be taken by the panel when it's said that exceptional circumstances arise on either side.
Sorry to interrupt, but a follow-up question. What would be these exceptional circumstances? What are you thinking about?
Well,
just give 1 or 2 examples, if you don't mind.
Very difficult to predict is really what I'm saying about that. We've had some discussions about what sort of circumstances could arise. They could be, for example, a vulnerable witness whose interview doesn't proceed as planned and who requires some more oversight from the registry, for example. So it isn't possible to predict all of the ways that this protocol could start to require some third-party involvement, but that's just one example. We suggest that it should, if it's there and the circumstances never arise, if the power is there to order it, then it may prove useful. That's all we'd say about it. And finally, on that topic, we endorse the SPO's proposal at 5b little 2 in their amended framework proposals, which is that WIPSO should be involved when they consider it necessary. And that, as Your Honour has seen, mirrors the position at the ICC, and we would say that for good reason, if WIPSO's evaluation is that somebody really needs them there, then that should happen, and that should be part of the protocol. So question 7, do the parties and participants consider the ICC model or another international model could be applied here? We say it constitutes a good model which has been adopted in cases of real complexity, and it would apply well here. So broadly, we invite Your Honour to adopt it. We've got a couple of qualifications to it. The dual status amendments that we have proposed is one. and the involvement of WIPSO is, as we've just suggested, also a valuable component. 8. Final question, should inter-partes discussions be conducted? Well, our position is that we are very happy to take part in discussions of that kind and to assist in promoting a final outcome that is more agreeable to all parties. We're very happy to do that. So unless there are any other questions for me, those are my submissions.
Thank you, Mr. Laws. Let me now turn to the defense, starting with Mr. Kihu. You have 15 minutes.
Thank you, Your Honor. If I may, Judge, I will talk briefly about the legality of the entire proceeding, but I would like to cede approximately 5 minutes to my colleague, Mr. Misicic, with Your Honor's permission, to talk about the ICC protocol.
Absolutely, as long as it's not more than 15 minutes in total.
Yes, sir. I understand. At the outset, let me just say it's unfortunate that counsel has seen fit to engage in ad hominem attacks. I thought they may have learned their lesson from the last time about the failure to turn over exculpatory material and then to mislead the court. Let me remind Your Honor that the only
Mr.
witness
Prosecutor, please.
that comes...
And
that,
Mr. Kihu, focus on what we hear today. Let's not waste time, and let's continue on the protocol, please. Thank you.
But addressing the issue as to the integrity of the system, absent the presence of the SPO, which we will get into in more detail. Let me remind the court that it was Ambassador Everts, interviewed by the prosecution, that said, while every single paragraph in his statement is accurate as written and can stand as it is, the totality of the statement seems to reflect a lesser interest in exculpatory than incriminating information. So, contrary to statements that somehow the integrity of the system is going to be maligned if the SPO is not there, it seems, in fact, it was maligned because the defense wasn't present. But as you can see from the protocol that the prosecution has put on the table, this is basically one way that they want to be in the interviews that the defense counsel has of witnesses, yet defense counsel is never present during any of the interviews conducted by the SPO since November of 2020, and there have been many, because we have gotten a significant number of witness statements just over the past year in 2021. So clearly, we will talk a bit about equality of arms. Your Honor can appreciate that there is no equality of arms except in the fashion that the SPO wants to dictate. Unlike the ICTY and the ICC and the ICTR and the other tribunals, this is a Kosovo court, and it is dictated by the provisions, to follow the provisions of the European Court of Human Rights, which are very clear about what the right of the defense is. And I cite to Your Honor the case that we cited in our submissions, Dayan versus Turkey, where the court talked about the accused investigative rights and noted the fairness of the proceedings that require that the defense be able to obtain the whole range of services specifically associated with legal assistance. In this regard, counsel has to be able to secure without restriction the fundamental aspects of that person's defense: discussion of the case, organization of the defense, collection of evidence favorable to the accused, preparation for questioning. Has to be able to secure without restriction. That's what the court said, the European Court of Human Rights. What the SPO wants to impose on this court and on the defense is with a tremendous amount of restriction. Let us start at the outset, and it's interesting to review their pleadings because they view the witnesses on their witness list as their witnesses. I don't want to repeat all the case law that we cited for Your Honor in our submissions, but the witnesses on the witness list are not the SPO's witnesses. They are witnesses, period, open to all sides to discuss, and it's not the SPO's witnesses. But when we look at what the legality of what is transpiring here, this is just another layer of the illegality that the SPO is attempting to foist on this court. We have 326 witnesses. Almost 50% of those witnesses have protective measures under Rule 80 already. I believe it's 48 point something. It is 157 out of 326 have protective measures. 103 are completely anonymous, with disclosure of those individuals coming at various times, 30 days prior to trial and even during the course of the trial. We have those protective witnesses, those protective measures for those witnesses at this point, 157 out of 326. Now the SPO wants to broaden the umbrella and put this restriction, their protocol restriction, on all witnesses, international diplomats, international officials, government officials, non-government agency officials from around the world, Germany, France, the UK, military officers, retired generals in the United Kingdom's military are under the protective measures being advanced by the SPO. Witnesses represented by counsel. I read an interview, a interview just yesterday with my colleague, Mr. McCluskey, of a witness who was represented by quite able counsel, had been a barrister in the UK, or had been a solicitor and a barrister in the UK for well over 40 years, and did quite well to protect the interests of his client. It is all of these people that the SPO is now attempting to preclude the defense from interviewing. And let's just go to the reason why. The reason why they put forth is to avoid re-traumatization of victims, witness, and safeguard privacy, dignity, and physical and psychological well-being. Is this SPO seriously arguing that a retired general in the British Army needs to be protected from some type of psychological damage because he's subjected to the interview, by Mr. McCluskey, for instance? Clearly not. Clearly not. What they're asking for is well out of line for what is the normal protocol in courts, international courts, and certainly a violation of the European Court of Human Rights. I mean, putting aside these wild allegations advanced by the SPO concerning prosecution's witnesses being undermined and placing enormous pressure on them to prove their patriotism by cooperating with the accused and distancing themselves from the SPO, that's in paragraph 3 of their most recent response. They do so with no evidence whatsoever. They do so with the fact that there has been no indication of any witness being impugned, impacted, injured, psychologically, physically, intimidated whatsoever. Have we begun to do interviews in Kosovo at this time, Judge? The last status conference, I advised the court that we had. Mr. McCluskey conducted quite a few interviews in Kosovo over the past month or so. And I trust there have not been any allegations leveled against Mr. McCluskey for the interviews that he conducted. So this whole argument that there is some specter out there of injury to their witnesses has got no validity in fact. And by the way, any of the allegations that we advanced against the SPO in proceedings before Your Honor are all true. But putting that all aside, there has been no substantive evidence or evidence whatsoever brought before us, before Your Honor, before anyone else, that somehow witnesses since the indictment in 2020 have somehow been impacted, damaged, or dealt with in anything other than a forthright manner. This is a specter of we want it both ways. We want control of the situation from the SPO. We want to have control of our witnesses when we want to talk to them, and we want to have control of the defense witnesses when the defense is talking to witnesses that are on the SPO list. And by the way, 326, they've covered the landscape of virtually everybody. They say that this is to avoid the re-traumatization of witnesses. Well, that's under Rule 80, Judge. And the time frame for bringing arguments before Your Honor on Rule 80 protective measures was in September. Not in December, January, and February. That is completely time barred. And going yet further, Judge, with regard to witnesses to get a protective measure, Rule 80, Subdivision 2 requires consent. Has been any consent advanced by the SPO concerning any of these witnesses? Has any of these generals in the British Army or any diplomats from the United States or France or from Belgium or from Germany, have they given their consent to any of this? I haven't seen anything in any submission by the prosecution or by the victim witness, which of course is required under Rule 80. I suspect that there is no consent was given whatsoever, and none was never asked. In fact, I submit to Your Honor that no request was made of counsel who represented witnesses. Counsel who represented witnesses to whether or not they consent to these protective measures. It hasn't been done. This is just an across the board, we want it our way position taken by the SPO. Now, with regard to the witnesses who happen to be represented by Mr. Laws, there is no problem there. We ethically are bound to contact Mr. Laws if, in fact, that witness wants to be contacted, if we want to talk to that witness. That is the reason why we wanted the identity of dual witnesses brought before the chamber, which is something we filed yesterday. Because once we know who those witnesses are, and the SPO knows who those witnesses are, we have to go through Mr. Laws as is proper, which we would have to do in any jurisdiction. But that's not covered by the SPO's filing either. The pros, without arguing everything we put forth in our submission, it violates the pros protocol violates the right to a fair trial. What is happening here is ruled by what the SPO wants to do. There's no equality in arms here. We were not entitled to participate in any of the interviews that the SPO has done or is continuing to do because their investigation is in fact continuing. They're interfering with the preparation of the defense, and they're interfering with the right of the accused not to incriminate himself. And the fact of the matter is they sit there across the table. They are invading the defense camp, all of which is in violation of the European Court of Human Rights that noted in Dakan versus Turkey, that we should be operating without restrictions. All of they're doing is putting restrictions on, in fact, what we want to do.
You're practically at 15 minutes, just...
I'm sorry, Judge.
If you want your co-counsel to speak, you have to give him the floor now, and he only has 3 or 4 minutes left.
Yes, Your Honor, we just say, having the SPO there, having this taped is a violation. Certainly having it, taped and having the SPO there is a violation of Rule 1045, because we were giving a pretrial statement before the defense is going to be put on. With regard to legality of that, I will turn to Mr. Misicic.
Thank you,
Your
Mr.
Honor,
Kihu.
I apologize, but I have a point of order to make. The Thaci defense has just made allegations against the SPO that are entirely false and that are defamatory. And the Thaci defense has once again misrepresented the content of the statements of Mr. Everts, just as they have done in the last status conference.
I'll stand by Mr. Everett's statements that have been submitted to the appellate.
Your Honor, I would be very happy if I can just finish what I have to say before Mr. Kihu interrupts me.
So very briefly, Mr. Prosecutor, you have less than a minute.
Counsel has again failed to mention both the inculpatory parts of that statement as well, and this is very important for what he just said, the fact that Mr. Everts was explicitly asked by the SPO at the end of his interview if he would like to provide any additional information or in any other way supplement or change his statement. Mr. Everts declined to do so, and what he had to say was inculpatory more than exculpatory, and to suggest that his statement has special relevance, either for detention review as he did in the last status conference, or as evidence of any impropriety on the part of the SPO, as he just did, is as dishonest as it is delusional.
15 seconds, Judge. We stand by what Everts had to say. The prosecution didn't turn it over in violation of their obligation to send over exculpatory information. They knew it, they got caught doing it, and that's why they're complaining about it now, and that's why we had to bring it before the Court of Appeals.
And one last issue, if I may, Your Honor. I would like to share with you that since joining this court, less than a year now, I've heard more false allegations of impropriety on the part of the defense than I've heard in all years before. Today, for the first time, we have clear evidence of impropriety. We have the Thaci team's written submissions that cannot be reconciled with a range of submissions they have made last year. And the Thaci team would be well advised to speak about that and not try to walk it back in the very slippery and implicit way they have just tried to do. Because obviously, pursuing defense investigations for 50 months is very different from doing it for 1 month. They are two different things. And Mr. Kiu would be well advised to address this issue and not make more false allegations as he just has.
I will now give the floor to Mr. Misetic. We will not continue this feud. We are here to discuss about the protocol. I mentioned specific questions in my order. This is what I need to issue my decision. So, Mr. Misetic, you have the floor. And forgive me if I make mistake when I pronounce your name. And I think in the previous status conference, I made so many mistakes that I really need to apologize. So you have the floor.
No apologies necessary, Your Honor. Thank you. Let me start out by saying as follows. In November of 2020, the SPO indicated they would be ready for trial in the summer of 2021. Obviously, they then proceeded with disclosure of witness identities and witness statements, thinking at the time that we were going to be in trial within 7 months. You were not asked to impose a protocol at any point in time while they were disclosing these witness statements. And so the underlying assumptions and presumptions of their submissions, which they made quite explicit this morning, is that defense counsel, we as defense counsel, somehow are suspicious, and you should be suspicious of us, and the, I would say in their submissions, perhaps even likelihood that we will tamper with evidence. I would remind the SPO and obviously the court that in order to even be qualified as defense counsel in this case, all of us had to go through a very rigorous procedure. And to the best of my knowledge, no counsel, no member of the investigative team has ever had an allegation, a substantiated allegation of witness tampering in our entire careers. And as a result of that, we were able to be qualified to represent people in these proceedings. So to the extent that the allegation now, which underlies the entire protocol, is that you should be suspicious of defense counsel, I think is contrary to what the established facts are thus far in terms of us being accredited. Secondly, the fact of the matter is this case has now been pending for 15 months. And again, we reiterate, and I'm frankly not even clear on what the allegation is by SPO counsel about our submissions. The point made by our submissions is that for 15 months, the SPO has disclosed witness identities and witness statements to the defense, and we have been free to interview those witnesses for 15 months. To the best of our knowledge, there has been no allegation by an SPO witness of any improper conduct by any defense team, not just the Thaci defense team, with respect to witnesses. What we do know thus far is that the only issue with respect to witness security that has happened thus far is the disclosure from the SPO of witness statements that were made public and which are now part of other proceedings at the SPO. These are the simple facts. Now, the underlying issue and what the SPO and Victims Counsel rely on, and what Mr. Kehoe alluded to, is a comparison between these proceedings and the proceedings at the ICC. And we would again reiterate that the ICC proceedings are not comparable to the proceedings at the KSC for one simple reason. The ICC or the ICTY or the ICTR are not bound by the European Convention on Human Rights or the jurisprudence of the European Court of Human Rights. This court is explicitly by both the law of the specialist chambers and the Constitution of Kosovo. And as Mr. Kehoe pointed out in his remarks, the case of Dayanan versus Turkey clearly sets out that defense counsel, in order to be able to do our jobs, must be able to do so, quote, without restriction, close quote, in the collection of evidence favorable to the accused and preparation for questioning. I know I'm running out of time, so the final point I wanted to make is there's also this assumption or this suggestion by the SPO and victims counsel that the obligations under the protocol will treat both sides equally. The point here is that the rules were set up not to treat the parties equally and not to treat their disclosure obligations equally. The SPO has a much higher burden of disclosure than does the defendant, the accused. The accused has no disclosure obligation for witness statements prior to the beginning of the defense case, and the accused has no obligation to disclose all statements by a witness, only those statements that the accused intends to use. Now, the protocol that's being proposed here puts us in the position as follows, and it was actually expressly now indicated by the SPO. For example, the SPO this morning said, or this afternoon I should say, said they want you to order a disclosure of statements and notes that have already been taken of interviews of SPO witnesses. That's in clear violation of the rules. There is no obligation for the accused to disclose statements to the prosecutor that could be used against him in the proceedings. It's a clear violation of the right against self-incrimination. And as a result, what we're now being asked to do is impose a protocol that says you, the defense, must now take statements, which we otherwise wouldn't have to do. For example, we could interview an SPO witness. We don't like what the witness says. We don't even have to take a statement under the rules. The protocol would now say you must create statements and you must disclose them to the SPO, and the SPO can use them against you later. What you're being asked to do is to produce a protocol that will force the accused to potentially create evidence that could be used against him. Again, and I would close with this, while that may be the case at the ICC, there's no decision at the ICC that has said this protocol we use at the ICC is consistent with the European Convention on Human Rights or has been found to be valid by the European Court of Human Rights. That's not the position that this court is in, and this court must follow the ECHR. Thank you, thank you, Your Honor.
Thank you, Mr. Misetic. Couple of questions, either for Mr. Q or Mr. Misetic. I'll let you choose who is going to respond. You insisted on the fact that this protocol would be contrary to the ECHR. Can you let me know which article?
I'm sorry, I missed that last part.
Which article of the ECHR would it be contrary to?
Well, I think if we read what the Constitution has to say, it is, we're talking about the KSC is obliged to follow Article 22 and 53 of the Kosovo Constitution and Article 3.2e of the law. And that requires the Kosovo courts to follow the jurisprudence of the European Court of Human Rights.
I know that. I'm asking you which article of the convention. Are you talking about Article 6?
Article 6, yes. Article 6 and the right to counsel and the right to a fair trial.
Right to counsel and right to a fair trial.
Yes, as Dayanan makes clear, it flows from the right to counsel.
Thank you. Would you consider that the ICC protocol, whether the one that is annexed to the Chamber's manual or any of the model adopted in different ICC cases, would be contrary to the ECHR?
Well, the fact of the matter is, as far as we know, it hasn't been decided by the ECHR, and as far as we know, the ICC has not explicitly said it's consistent with the ECHR. But yes, to the extent that the protocol requires an accused to create evidence that can be used against him, yes, we do think it would violate the ECHR.
And when you indicate that it is contrary to the ECHR, is it only the specific point that you just mentioned? Or is it broader than that? Is it the principle of the protocol? Or is it in between the two? Is it the fact that there is any regulation of the defense investigations during the pre-trial, the trial phase?
Well, it's also in the collection of evidence. For example, if we're put in the position of choosing to either risk creating a record that could be used against the accused or not interviewing the witness at all in order to avoid the risk, that then implicates a different right under the convention in terms of the right to investigate the case. That would be the right to counsel, basically, because the right to investigate flows from the right to be represented by counsel. And so we would have to be trading off rights under the convention, because we'd have to just say, well, it's too risky to interview this witness because we don't know what they'll say. And then the SPO can come into court later and say, even on the defense questions, even on the questions of the accused, the witness said X, Y, and Z. So we won't investigate it at all, which now hinders our ability to conduct cross-examination because we haven't even had an opportunity to meet with the witness, interview the witness, see what the witness will say. It implicates other rights in the sense that frankly, the SPO will be sitting in the room, and I'll give you another hypothetical example. If we're in a witness interview and a witness says something that the SPO didn't know before that's going to be highly exculpatory for the accused, the SPO decides that as a result, they're not going to call the witness. And this relates to a topic that was discussed at the last status conference about the potential for the SPO to be asked to reduce the number of witnesses they're going to call. The SPO decides, as a result of being present at a defense interview, we're not going to call these witnesses, and now the defense has to call certain witnesses as part of the defense case that were on the SPO list. Now you have a violation of Rule 104 because they now have a defense statement that they otherwise weren't entitled to have before the defense case, that they now have as part of their case, and that, as Mr. Kehoe used the language, they invaded the defense camp and now have an opportunity to see what the evidence is that the defense hopes to emphasize through certain witnesses. So the main point of this is that the rules were structured in a way that is not symmetrical. And that is part of the submissions of victims counsel in the SPO here is, well, the protocol applies equally to both sides. Everything's fair because it applies 50-50 to everyone. But that's not the way the rules are structured. The burden is on the prosecution entirely at this phase of the case. They have all the disclosure obligations. The accused has none. And now 50-50 is actually a violation of the way the rules are set up. And I would also add that there is a very specific reason why the rules don't say when the defense case starts, the accused must produce all witness statements of the witness. They don't say that. They say the statements that the accused intends to rely on at trial. But if we were to have other statements of a witness that for whatever reason the accused decided not to submit, the court has no right under the rules to force the accused to submit them. Your protocol now would essentially require that because it would require the accused to start producing statements that he otherwise might not want to produce and that they could be used against him in the proceedings. We do submit that that would be a violation of the convention.
But Mr. Misicic, you know that in several systems in Europe, probably even the majority, but I'm not sure of that, the defense doesn't even have the right to question witnesses before the trial, or at least before the investigation judge when you are in a model where you have an investigation judge. So I struggle with your arguments that even the principle of such a protocol would be contrary to the ECHR when a lot of jurisdiction within the ECHR do not even provide for the possibility for the defense to conduct investigations.
That may be the case, but you would have a situation then in a civil law system, for example, where the questioning is being done by the investigative judge and the accused has the right to ask the judge to interview certain witnesses as part of the investigation. Here, that's not the way the court is set up. So while we could make the argument that if we were in a civil law system, then the judge would be doing all the questioning and there would be no risk of the accused himself creating evidence that can be used against himself. But we're now in a model system where the SPO has a right to investigate its case and the accused has the right to go out and investigate his own case, right? And you're being asked now to say, and what you produce can be used against you in the proceedings before the court, which I don't think would be the case even in a civil law system, but whatever the case may be, where the accused would be required to produce or turn over evidence that otherwise wouldn't have been created to be used against him. So the point is, if we have a system that is set up this way, then it must be set up in a way that the accused has the ability to conduct an investigation and isn't put in a position of conduct an investigation and risk creating evidence against you, or don't conduct an investigation at all, which is what the situation we're in now.
Thank you, Mr. Misitic.
Just one last comment with my counsel referred to, Mr. Misic referred to Rule 104. What we were talking about is Rule 104, and our obligation to turn over information is the defense, should it choose to present a case. I'm talking about Rule 104.5. Should it choose to present a case, shall, within the time limit set by the panel, and no later than 15 days prior to the opening of the defense case. So, under the protocol that is advanced by the SPO, they would have witness statements prior to the defense ever making a decision about putting a case on in violation of Rule 104.5. That is the regime that was set up when these rules were set forth. So, going back to Mr. Misic's example, we have an interview of a witness, and a witness gives certain information that's exculpatory. The prosecution decides not to put that witness on. The defense is then in a position of having to put that witness on. They put it on with the SPO being in possession of that witness's statement from the conversation with defense counsel in violation of Rule 104.5. So just following the particular rules itself, putting aside the regime of the ICTY, the ICC, and the ICTR, these rules drive what we must do, and the protocol that they have set up clearly violates Rule 104.5 based on the scenario and hypothetical Mr. Misic spoke about and I just alluded to.
Thank you, Mr. Kihu. Let me now turn to the Vasily defense team. Is it Mr. Emerson or is it Mr. Strong?
Sorry, it will be me for the time being, I'm afraid. Can I make 2 or 3 general points at the outset before, as quickly as I can, running through the list of questions? And
yes, but that will be within your 15 minutes then.
It will absolutely be within the 15 minutes. And I note that we're beginning at 14:47, so I'll make sure that I'm finished within the time frame. Okay, 15:30. All right. So first of all, and I'm just making general points at this stage, I would invite you to consider how the position and arguments advanced by the prosecution can be reconciled with the mandatory presumption of innocence. It doesn't seem to have affected or been raised within the prosecution's submissions, which are based on 2 fundamental propositions. One is that the accused will wish to interfere with the course of justice through their counsel. And the second, and this is a direct allegation against defense counsel, which itself is in breach of the rules that prosecution counsel has been objecting to, that in light of some of the points that defense counsel have made in the proceedings, in these open proceedings, they can't be trusted to comply with the Code of Conduct when dealing with witnesses and are likely to interfere with witnesses. That is, of course, a hugely defamatory comment and entirely inconsistent with the rules and prosecutorial misconduct. But I'd like to deal with it because it's extremely serious proposition. But before we turn to that, I want to invite Your Honour to look at the way the case is put with the presumption of innocence of the accused and, frankly, of counsel in the way this has been put most recently. Is fully respected all the way through the decisions that you have to make. I'm not going to say to you what exactly the implications of that are, but it's a rather shocking omission from this discussion. Secondly, the key question here is proportionality of the scheme. And when counsel for the victim stood up, he said at the beginning of the conversation, of his submission, that he wasn't sure he really had standing to speak about those witnesses who were not victims. He's right, of course. He only has standing to make representations on behalf of victim witnesses, and he has no standing, as as I thought he conceded, but then made submissions about, to address the question whether all protocol. A protocol, we need to look at what the prosecution says the protocol is for, and ask ourselves whether the methodology established for it is reasonably tailored to meet the objective it says that it's seeking to pursue. Now, the objective, and I'm quoting the prosecution here, is to avoid re-traumatization of victim witnesses and to safeguard privacy, dignity, and physical and psychological well-being. Well, with the greatest, there can be no question of organising non-victim witnesses. So the first issue is, why on earth are we including non-victim witnesses in this protocol? There can be no reason why, other than the allegation that the defence are going to do something to corrupt the witness in one way or another. I find that, of course, professionally hugely offensive suggestion, and indeed the way counsel put it was laughable or can't be taken seriously. That the opposite would be true, which is an extraordinary example of the very worst of what the prosecution is trying to say about the defence submissions. So, first question is, what does proportionality require in the context of a scheme designed to avoid...
The interpreters don't hear the counsel. Sorry.
Why would that be? Is that a problem at your end? Can the court hear me?
I can hear you, but I think we sometimes hear a sound over you. So I don't know if there is a microphone that is still on in any of the other Zoom participants. If it's the case, I invite all of you to put your microphone on mute, and it should be fine. And maybe if it's from the last screen, maybe the AV can also mute the last screen on the big screen in the courtroom, if it's possible. Mr. Emerson, please proceed.
Yes, so proportionality is the first thing. Certain examples have been cited to you, such as the internationals who are giving entirely. And obviously, it's self-evident that at that end of the spectrum, this system should not be applicable. And there's no justification whatever for applying it. And with the greatest of respect, it seems to me, and I would make this submission, that at the very least, you should exclude anybody who is not alleged to be a victim. And that at least will reduce the scale and scope. We are dealing with 300 and, I'm sorry, I've lost the number. It's either 320 or 360 witnesses. And so anything that can be done to keep this manageable and not to derail the trial needs to be done. Otherwise, we'll end up with a 2-year pre-trial delay whilst these witnesses are all put forward. A significant number of them are put through this mincing mill. And I'm sure many of us, certainly I, would be reluctant to be interviewing victim witnesses in advance. Very often they have little to say about the issues in the indictment, but only about their personal experiences. So I can't say that would always be the case. There may well be cases where we do need to apply via the protocol, but realistically, it is significant interference with the defence in relation to witnesses who are not victims. And so far as the procedure adopted in the ICC is concerned, it is very important to remember the distinction between adversarial and inquisitorial proceedings. Obviously, an inquisitorial procedure is compatible with Article 6 of the Convention. That's self-evident. And so it can't be that an ordinary inquisitorial process with all its own safeguards is in violation of Article 6. But at the same time, if you're in an adversarial process, you can't borrow in bits from an inquisitorial process and say, well, it works there, it can work here. An adversarial process is entirely different in the way that it's set up. It's set up so that each party presents the evidence to the court and the court makes the decision. And obviously, cross-examination is an important tool, But above all, and this has been accepted by international tribunals when they're confronted with some issues about adversarial inquisitorial proceedings, in any event, confronting a witness in cross-examination with a piece of information that they perhaps are responding to for the first time. I mean, this may not be the protocol issue, but you may have information independently sourced that you put to a prosecution witness. Their reaction first, at the first presentation of it is a critical tool for evaluating credibility and reliability. And that presupposes an element of surprise. It's not trial by ambush in adversarial proceedings. It's a process where each side is trusted to present the evidence. And if the prosecution is going to say, well, you can't trust the defense to do anything because they're rule breakers, and it's a laughable proposition that they would genuinely interview a witness and not seek to interfere illegally, commit a crime of interfering with the course of justice, then I'm afraid the whole system has collapsed. It's premised upon the trust of counsel, and that disgraceful suggestion this morning ought to be withdrawn. It won't be withdrawn because the prosecution continues with a brass neck all the way through these proceedings. Now, I want to address one aspect, and then I'll rush as quickly as I can through the questions. I don't know whether I need to address you in detail on the ludicrous submissions of the prosecution, the issues that have been raised in court, in open court, and the subject of argument about the prosecution's conduct in these proceedings are in themselves a threat to witness cooperation. That was elevated at this hearing into being evidence that we, counsel, could not be trusted not to commit crimes because we're so evidently criminal people. That is what we're dealing with. Now, I have to address that for obvious reasons. The reality, as you know, because you've sat in every pre-trial hearing, is that the issues that have been raised by the defence against the prosecution relate to misleading statements about how long it was going to take for the prosecution to be ready, about misleading statements by the prosecution that the defence were elongating the realistic pre-trial period dishonestly in order to inflate their chances of provisional release. It relates to the fact that the prosecution repeatedly failed to meet its own deadlines, misled the court in numerous respects, and that the prosecutor himself addressed a meeting of European ministers, of European ambassadors, and made astonishing statements about the accused, the first accused being guilty of the crime with which Mr. Haradinaj and Thaci were charged, even though he had no evidence he acknowledged to prove it. And so we've had a terrible series of acts of prosecutorial misconduct, and it's true, and I accept the rebuke, that my tone may have reflected my feelings, which is a deep sense of shock that the prosecution has behaved in this way over a period of time, and that they've been allowed to behave in that way. And so it is possible that I have a tone which I need to be entirely committed to doing. But to say on that basis that I'm the sort of person who would commit a crime in the preparation of the defence case is a disgraceful slur, and is a good example of how the prosecution has completely lost any sense of rationality or reasonableness. I mean, it's desperate stuff. As far as the protocol is concerned, as I say, we can start from the proposition that it's clearly far too broad in terms of the witnesses that it covers. A simple way of cutting it down very significantly is to confine it to those witnesses that victims' counsel is legitimately able to make submissions on, namely those who may be re-traumatised by even thinking about it. I mean, re-traumatisation is likely to happen to those who feel are liable to be traumatised by the hearing, by the publicity surrounding their giving evidence, by the whole process. And that, I'm afraid, is one of the consequences. It's inevitable. It's not to do with being interviewed by the defence. It's to do with the entire process that they're going through. There is a risk that some people, particularly those suffering from post-traumatic stress disorder from an event, will find themselves re-traumatised, and no doubt the court will give them full psychological and social support if they need it. So that in a sense, I can't take it any further than saying that we're obviously dealing with a situation where a prosecution has lost focus. It's put 26 witnesses on the witness list to be called, which, as I've said last time, equates on past trial experience to something like a 4 to 5 year trial. Whatever the prosecution says about the fact that they're different from other tribunals, that's exactly what they said about how long it would be before they were ready for trial. The prosecution says whatever it wants to deal with the short-term interest or the issue before them, knowing, or at least being reckless as to whether there is any truth whatsoever in the predictions that they're making. You've seen it happen over and over again. So, I mean, as far as that is concerned, we would suggest the prosecution is not seriously attempting to engage with the underlying issues of really genuinely looking at re-traumatization. Instead, it's splashing slurs against defense counsel, creating a protocol that covers 360 witnesses, including internationals and police officers and people of being intimidated. And it also includes people who've gone public about the fact that them voluntarily gone public about the fact that they were interviewed by the SPO. Numerous people who are on the witness list were later, are following their interviews, returned to Kosovo and announced that they'd been interviewed. These do not look like witnesses who would be intimidated by an interview professionally conducted by defense counsel. So I'm afraid you're being given a pile of what we used to call pants from the prosecution. There's nothing in the suggestion that a protocol of this breadth is necessary in this case for this number of witnesses. That's essentially, I'm taking it from that end rather than what I think it ought to be. Your first question asks about specific legal basis and about other comparable tribunals. I mean, the borrowing of different protocols from the ICC and taking them at their highest, in other words, as you say, the question that you asked the prosecutor, not mirroring any one of them, but combining them to create the most oppressive possible regime. That's one way of going down this route, but it doesn't lead to proportionality in a case like this. I mean, when you look at the cases to which those kinds of protocols have been applied by the ICC, you know, in Bagbo and Manga and so forth, you're looking at cases where the witness numbers were tiny by comparison to the case we're dealing with. And I mean, I can give you the statistics if I can find them. Sorry, just a second. What is somewhere? Hang on. There is, yeah, I'll come back to that because, yeah, I think I know where I've got it. Hang on. Sorry, I've lost that statistic, but we're talking about trials with sort of between 40 and 60 witnesses. And of course, they weren't subject to a protocol as absolute and extreme as the one that you're being presented with, but which has been culled from the most extreme aspects of what the prosecution is able to envisage. So the point you make about witnesses happy to be interviewed by the defense in the absence of anybody is a very good one. But there are others. But there's also an entirely different mindset adopted by the ICTY, which is a practice that applies to the Balkans and was applied to the Balkans and Kosovo as well. And you'll find the sort of leading authority in Merksic, which is, and it's the principle is that it's the same as the principle in all adversarial proceedings, which is that witnesses are the property of neither the prosecution nor the defense, and thus both parties have an equal right to interview them, not the prosecution has the right to do it in private, use it, but the defense must do it in the full glare of the prosecution and others. And it's a very common phrase used quite throughout the common law world on which the proceedings here are based. That there's no property in a witness. So the ICC approach is to say the calling party has a certain proprietary interest in the witness, but the ICTY approach, which is far more faithful to an adversarial procedure and consistent with the process in Kosovo, this being a Kosovo criminal court, is that there is no property in a witness whatsoever. And I'll read you the passage very briefly in the Merksic decision. This is, I'll provide the reference. It's 30th of July 2003, paragraph 13, and it's a decision on the defence interlocutory appeal on communication with potential witnesses of the opposite party. And the trial chambers rejected, in that case, a defence application to establish rules governing communication with witnesses because they didn't want the prosecution coming and interviewing their witnesses in a manner that had no regulation in that case. The appeals chamber upheld the decision that there should be generally no such protocol, but went on to say, where, however, a person for any reason declines to be interviewed, the prosecution does not have the power to compel that person to attend an interview. And paragraph 3, 18, 19 of the decision say exactly as we have here. No, there's no rule in the KSC rules which justifies this process. I mean, it's all to be inferred from the objectives and particularly Rule 80. We say, fundamentally, Rule 80 requires a witness-by-witness decision. But obviously that would be unworkable in practice, so we're hoping to find fine categories. Now, clearly, any witness who does not wish to be interviewed by the defence is entitled to refuse. Any who only wishes to be interviewed with victims' counsel is entitled to victims' counsel, and so forth. And
Mr. Emerson, please conclude this now. More than 19 minutes.
No, that's not right. I started at 14:47, and so my time expires at 15:17, and it's now 15:06. So I think I'm right.
It's 15 minutes per counsel, Mr. Emerson.
Yes, isn't that right? Have I not got that correct? 47, 15. Okay, well, I'm very nearly where I was at the end. So the only other issues that I need to touch on, that's the question of legality, as far as the basis for the provision is concerned, the basis for the protocol is concerned. That is your first question. And your second question also, I think I've addressed, which is whether or not it should apply to all witnesses. The third question is addressed to the prosecution. You've heard our submissions in relation to that. Do the defence teams intend to organise joint interviews? That has not been the subject of agreement between the defence, but it does seem to me there's force in the submission that should happen whenever it's possible, and that only in exceptional circumstances should witnesses need to be interviewed more than once. The adjusted proposals, well, I say, as I've already submitted, they are lacking in proportionality and precision and unworkable in practice given the size of the case and the number of witnesses involved. That's why we suggest that the ICTY is a more suitable approach in the context of an adversarial procedure. But we entirely understand that if Your Honour does consider a witness protocol to be necessary in relation to categories, because otherwise every single one would have to come to you, then it's a very significantly narrower category than the category the prosecution is relying on. And I think that's everything I have to say.
Thank you, Mr. Emerson. Mr. Prosecutor, did you want to say something? Really very brief, because then we have to break for the interpreters before the two remaining defense teams.
Thank you, Your Honour. I would just like to note that I would like to make two further points in response to what has just been said. And I promise that I will be briefer than the time that has now been ceded to the Thaci and Ksc defense teams. But I'll be happy to do that after all counsel has addressed the court.
The interpreters kindly ask all the other microphones to be switched off. We think Mr. Emerson's microphone is still on and his sleeve is rubbing against the microphone. That's why we're having difficulties. Thank you.
I think we've solved the problem of the sound that we could hear from time to time. It's now 4:09. We're going to break for 21 minutes until 4:30, and at 4:30 we'll reconvene with the Selimi defense team. The hearing is adjourned.
All rise. All rise. Please be seated.
I will now give the floor to Mr. Tully. You have the floor, please.
I thank you, Your Honour. I will attempt to be as brief as possible. I know that counsel for Mr. Thaci and for Mr. Vaselli have covered a lot of the points quite comprehensively. And just before I begin, I'd like to say that we support all of the points they've made so far. I'll attempt to add to them as much as I can, and I'll try to avoid any overlap. I'll deal with this question by question. So on question 1, regarding the specific legal basis for the proposals set forth in the SPO submissions, our view is that the most important rule that's been cited here is Rule 80, Your Honour. We are aware of the fact that in the first written submissions and in the second written submissions of the prosecution, there was no direct invocation of Rule 80. It was referred to, but it was never directly invoked. And this was noted by counsel for Mr. Thaci on Monday. Nevertheless, Your Honour, the language of all of these applications, including the submissions of the prosecutor in court today, show that this is very much an application, this protocol, that is grounded in the bones of Rule 80. And along with Rule 80 comes a requirement to meet the legal standards of such an application. And in our submission, the SPO has failed to do so. So a brief note on the legal basis for protective measures according to Rule 80, Your Honour. By their very nature, protective measures run the risk of curtailing the rights of the accused. For example, a delayed disclosure might hamper the rights of the accused to prepare an effective defence, or protections of anonymity run the risk of violating the right to a public hearing. So because of this risk, and this is something we ask you to bear in mind when making your decision, protective measures are exceptional. They are the exception to the rule. They should not be taken lightly. And most importantly, they should not improperly derogate the fair trial rights of the accused, which we submit to you is happening exactly here, and this will happen if the protocol is adopted. So the balance between the rights of the accused and the witnesses, I'll give a headline, as my colleague also did. We submitted it in our written filing of the 15th of December, is that in Article 42, regarding the conduct of proceedings, it's noted that there must be full respect for the rights of the accused and due regard for the rights of the witnesses. This is that when the two things come into conflict with each other, the balance must come out in favour of the accused. And this is reflected in Rule 80, which states, quote, that measures may be imposed provided the measures are consistent with the rights of the accused, end quote. So some other things to bear in mind before I move on to the specific submissions of the prosecution is that first, the burden rests on the party seeking measures to justify in each case why they should be granted, that is, witness by witness. Second, protective measures have set requirements. This is well set out in the jurisprudence of various different international criminal courts, but we don't have to go too far afield because they are set out also in the annex to the Ksc and Haradinaj decision, from which the prosecution more or less copies and pastes the proposed protocol. It's in the section immediately preceding the section where it is lifted from. And that says, if I can bend your ear for 1 second, Your Honour, that a party seeking protective measures, quote, shall indicate with specificity the circumstances objectively justifying the issuance of those protective measures. So we distill this down to the SPO must specifically identify the risk to be alleviated in each case and why the proposed measures will alleviate that risk. And finally, before I move on to the submissions of the SPO, the balance between the rights, and this is something I refer to in regard to Article 40 and the wording in Rule 80. The balance of the rights means that there's a well-established principle that any measures imposed must be the least restrictive necessary to provide the protection of victims or witnesses. And the latest iteration of that I've read is in Kamuhanda on a decision on appeal of a decision rendered by a single judge dated the 6th of the 10th, 2017. So, Your Honour, if I can move on to the submissions of the SPO in this regard. In our view, the SPO has not met the legal requirements of Rule 80. In the initial protocol, there was absolutely no attempt to justify the protective measures, nothing. There was vague references to the dignity, the safety, the well-being of the witnesses. We understand this. This is something that's present in every one of these trials. Nobody is ignorant to these issues. But there was no attempt to clearly identify any witness at risk. The defense responses on the 15th of December, I believe to a T, asked them to justify these risks. We pointed out the deficiencies in what they had just done. and no response, no reply, nothing. We heard nothing for 2.5 months until Your Honour ordered responses to the submissions of the registry. And on the 14th of February, we're introduced to this new phrase. This is the integrity of the evidence. This is something that's not contained in Rule 80, and it's not something that appeared in the 3rd of December filing. So why does it appear now? Well, Your Honour, I'm referring to the allegations levelled against our colleagues. And these are selective quotes taken from submissions of our colleagues. And in our view, this is a late-stage attempt to justify their application, the Rule 80 application, by issuing baseless and unsubstantiated accusations against our colleagues, presumably to the defence as a whole. So, Your Honour, whatever else these accusations are, and the counsel who have gone before me have specifically addressed these, and I don't want to go too much further into them, whatever they are, they certainly are not an objectively justified risk, nor do they fulfill any of the other legal requirements necessary for a protective measures application. And so, to finish on this point, the SPO has failed to satisfy the legal requirements of the Rule 80 application that they are attempting to make. Now, I'll move on to question 2, Your Honour. Our position on this largely ties into our first. We share the same concerns of both counsels for Mr. Thaci and counsels for Mr. Vaselli when they called into question the absurdity of the proposition that these measures would apply to every single person on the witness list. I believe diplomats, generals, so on and so forth have been mentioned. We share those concerns, and that's not the point of my submissions here today. In line with our submissions on the first question, our submission is very simple. An individual objective risk assessment must be carried out, and the measure is justified on a case-by-case basis. To be clear, Your Honour, we are not opposing any idea that a protected measure is brought in against a witness, and we resent any insinuation that we are. What we are asking simply is that the rules and procedures that have been there for years, that every other prosecution in other courts, and the prosecution here has previously followed, that they do so here if they are making a Rule 80 application. They tell us they're making a Rule 80 application, we ask them to do it properly. That is all. So, Your Honour, and finally on that point, again, to remind you, if the measures are to be imposed, we ask that they are the least restrictive in order to ensure that specific protection to the victims. Moving on to question 3, the position regarding the right to a fair trial. Again, not to echo myself too much, but we share the concerns of our colleagues, specifically regarding the violation of the specific rights against self-incrimination and the right to prepare a defence, and we have nothing more substantial to add on this. But a note on the violation of the equality of arms, Your Honour. This is something that is a difficult topic to deal with. In our view, to make it clear, our proposal is that our view is that this proposed protocol is a one-sided affair. We see these as measures that are being unilaterally sought against the interests of the defence, and this should concern you. This concerns us, and we ask that it concerns you too. Now, when we turn to the formulation of the equality of arms, my colleague Mr. Kehoe used a different formulation to the one I do, but I also support the formulation used there. But for my purposes, I believe the clearest statement of the principle is this, and it comes from Ksc. This is that a person must have a reasonable opportunity to present a case under conditions which do not place them at a substantial disadvantage vis-à-vis their opponent. And that's all we ask here, Your Honour. This is a simple formulation, but where the difficulty comes in is where we apply the equality of arms to the circumstances of the case, because this is inherently a subjective application. How do we determine whether equality of arms has been breached in a given case? The circumstances of each one are different. The parties have different resources, which doesn't necessarily lead to an inequality. But we are putting to you that there is, in this case, enough pointers that should be triggering alarm bells in your mind that this is a violation of this specific right. One specific point that's important for assessing this violation, Your Honour, is that where a proposal only affects one side, it should trigger those alarm bells. And we have submitted in our written filings, and we resubmit here, and we echo the submissions of our colleagues, that the party-neutral language that is used throughout this proposal is a smokescreen. The protocol targets defence almost exclusively. This can be discerned from looking at the context of any of the position of the defence in any criminal trial. We ask you to bear in mind that the defence has no obligation to call witnesses, and the burden of proof is on the SPO. You've heard this already. But not to put too fine a point on it, but the defence needs to prove nothing. The prosecution needs to prove everything. This is reflected in Rule 104.5, where it states the defence, quote, should it choose to present a case. This indicates the discretionary nature of this choice. That is, the defense can put the prosecution to proof on its case, which it has done so successfully in the past. And we ask that we have the same opportunity to do that again today. Excuse me, do it through these proceedings. Now, obviously the specifics of the provision regarding the videotape threaten the discretion not to call the case. I'll deal with them separately. But Your Honour, even if the case is called by the defence, there is never a parity in the number of witnesses. Internationally or domestically, the numbers are not even close, especially in this case. We are talking about 300 plus witnesses. So we ask you now also to consider the stage of proceedings and the position the defence is in now. Yes, it has been possible to carry out certain investigations in the past, but we are only now in receipt of the information that would provide the key to us to begin in earnest the investigations. Our view is that when you are reading this protocol, whenever you read, quote, calling party, realistically, this should be read as SPO, and opposing party, realistically, should be read as the defence. Now, Your Honour, in our view, the SPO response on the 14th of February 2022 effectively confirms this, and I'll offer 4 points in support of this. First, we see the accusations against our colleagues as an attempt to ring-fence the entire witness list as the property of the SPO. And second, the unsubstantiated claim that, quote, all witnesses face enormous and improper pressure to prove their patriotism by cooperating with the accused and distancing themselves from the SPO, again, without evidence, without reference. Third, the unsubstantiated references to alleged, quote, risks to the integrity of the evidence simply by virtue of defence investigations being carried out. And Your Honour, finally, and this is where we believe the mask truly comes off, is the revised position in the latest round of submissions that in fact the most important part of the protocol is simply that the SPO is present in all interviews, and this cannot be waived by the witness. To bring you back to the theme of my submissions, this has not objectively been justified, along with the requirements of Rule 80. And we ask you further to take into account 2 other matters before I move on. The SPO has gone straight to seeking a judicial order in order to carve out all witnesses as theirs, and this is to ring-fence witnesses as their property. There's no need to repeat the already provided submissions on the property in a witness. And second, as they are not following the established procedure of applying for protective measures and instead are appealing to the discretionary power of the judge, should trigger yet more alarms in totem. In conclusion on this point, these points, in addition to those previously made in our written filings, support the position that this is a one-sided affair and that equality of arms is under threat by the proposed protocol. Your Honour, if I can move to question 4, it's brief, and this is, do the defence teams intend to organise joint interviews? We are always open to working with our colleagues. We would endeavour to do so at any point in the future, but we would like to point out that our position is that this must be done at the decision of the individual defence teams and not forced upon us. The simple matter is the logistics of the defence team, the different stage in investigations that we are in, may prevent us from carrying out those joint interviews effectively, and a rule which would force us to do so may result in the lost opportunity to interview a witness. It also may be the case that there are different interests of defence teams in interviewing those witnesses. Now, we are conscious of the fact that it has been raised that witnesses might have to submit to 4 interviews, but we would also point out that the consent of the witness has not been negated here. If the witness does not wish to appear for 4 interviews, then they can simply say so. And number 5 is not directed at us. And number 6 is the position of the defence team's Victims' Council and Registry in relation to the adjusted proposals set forth in the SPO's response to the registry submissions. Again, we support the submissions of our colleagues in this matter. I have brief comments regarding the obligatory presence of the SPO in witness interviews. Our concern can be distilled as this. We have concern that this will have a chilling effect on the witnesses who would appear for interview with us. Whether these are witnesses who may feel compelled to help the SPO, not be forthcoming, and specifically not to be forthcoming to the defence with their evidence, out of fear of the prosecution, whether they are suspect, people who have been interviewed as suspects previously, or those who have a desire to help one side over the other and withhold exculpatory evidence for any other reason. So the logic of the SPO submissions on this topic cuts both ways, Your Honour. We have one final submission to make regarding the videotaping of witness interviews, Your Honour. I realise that this is not actually in the latest registry submissions as a point. However, it is referred to, and it's referred to as appropriate and necessary. So, Your Honour, to remind you here, this is not a proposition that witnesses are videotaped simply for transparency. This is not a simple record of the interview. The proposals are that they are videotaped, the defence investigations are videotaped, and then the party has the right to enter this into evidence. So our obvious concern would be the revelation of defence investigations and the lines of questioning that are carried out during these interviews, and we need to be free to carry out those investigations with fear that they might not hurt the interest, without fear that they might hurt the interests of the accused. But specifically on this point, Your Honour, what we're interested in is finding out what is the connection between the protection of witnesses and the use of those videotapes in support of the prosecution's case. Surely these two things are separate. Charges against the accused are levelled by the SPO. Why would they need their hands on these tapes in order to support that case? And Your Honour, the elephant in the room on that submission is that the measure benefits the SPO immensely, and there is no tangible connection to the protection of witnesses. Regarding the model adopted at the ICC, we support and endorse the position taken by our colleagues for Mr. Thaci. Thank you, Your Honour.
Thank you, Mr. Tilly. You mean that you support the fact that it's against the CHR, correct?
Yes, Your Honour.
And on that specific note, it's with the same argument as developed by the Thaci defense.
Yes, Your Honour.
And does it mean that basically the right against self-incrimination is infringed when basically you have to disclose any material during the investigation phase, correct?
That is correct, Your Honour, yes.
But, I mean, I will follow up on what I was saying earlier. You know that in most civil law systems, even when the defense get to interview any witness, this is before the investigation judge, and there is no privilege against self-incrimination because then the defense has to disclose it before the court and the prosecution can be here at the same time.
Yes, Your Honour, we're aware of that, but our position is that by disclosing...
And I'm not trying to trick anybody. I'm just saying that, I mean, if you say that this is a problem, then it means that it's a problem for a large number of European countries.
Well, Your Honour, I'm not... It's a tricky situation. I'm not in the habit of trying to insult any other systems, but our view is indeed that this is a violation of the rights of the accused. I don't want to get too much further into it than that, but this is, if we see the disclosure of this information is a violation of the rights of the accused.
Thank you.
Okay, thank you.
Let me now move to the last defense team. Mr. Bayezu, please.
Thank you, Your Honour. The Krasniqi teams strongly supports and adapts the submissions made by the other defense teams in opposing the protocol. The key problem is that the prosecution seeks to impose a blanket protocol on all the prosecution witnesses without any attempt to establish that all or even that any of those witnesses assessed in their own circumstances actually need the protection of the protocol. If an individual witness requires protections, let the prosecution make an application. But the court must avoid applying protective measures to all the witnesses in this case, many of whom, for instance, the international witnesses, have no need for such protection. On question 1 from the agenda, identifying the legal basis for the protocol is revealing for the following reason. Rule 80 might provide a basis for imposing protective measures for a particular witness where the necessity and proportionality of those measures is objectively established to the required standard. It does not and cannot provide the legal basis for the imposition of a blanket protocol applicable to all witnesses. The text of Rule 80 makes it clear that any protective measures must be consistent with the right of the accused, that the consent of the relevant witness should be sought, and that the protective measures have to be appropriate in the specific circumstances of the case. As early as in the framework decision on disclosure of evidence and related matters, filing F99, the court made it clear that protective measures need to be assessed on a case-by-case basis. That assessment has been carried out on every application for protective measures. The fundamental problem with this protocol is that it effectively circumvents any assessment of whether a particular witness needs a particular protection by seeking to impose a protocol on all witnesses, regardless of any showing of the need for such measures. Even, tellingly, in the prosecution's latest submission, regardless of whether the witness actually wants the protection or not. The second question, with your permission, Mr. Ellis is going to be making our submissions.
Thank you, Mr. Bayesu. Mr. Ellis, please.
Thank you, Your Honour. May I start by saying this and simply this. We fully understand and support the desire to protect the dignity and the privacy and the well-being of witnesses in this case. We're alert to the need not to re-traumatize the victim witnesses, and with or without a protocol today, we have no intention of acting in a manner that will affect the dignity, privacy, and well-being of any witness in this case. The best evidence in support of that is that we've been in possession of disclosure of witnesses' names since the very first disclosure batches in December of last year, and we're aware of no complaint against our activities in the many months that have passed. Question 2 on the agenda item is an important one in our submission, because whether this issue is looked at through the lens of Rule 80 of the rules, or indeed more generally through a human rights framework, proportionality is a critical question here. Protection to those witnesses who need it, but not protection to every witness in circumstances where there is no showing of any objective need for the measures sought. And it is the blanket nature of the protocol that the prosecution seeks to impose that is the clearest evidence of its overreach in our submission. Amongst the 300 or more witnesses on the prosecution's list, there's a diversity of backgrounds, of positions, and in the content of the evidence that the witnesses could give. And many of those witnesses simply have no need of the proposed protocol. The clearest example that all defense teams have given, and I rely on again, is the example of the international witnesses on the list. We have here more than 30 who are senior political and military officials from international organizations, from states, from NGOs, expert witnesses. These are exactly the sort of witnesses that the defense may wish to speak to. But what justification is there for imposing a protocol on contact with those witnesses? Is it seriously being said that a high-ranking military officer is going to be afraid of speaking to the defense? Or seriously said that an interview with the defense would traumatize or affect the dignity and privacy of such witnesses? Clearly not in our submission. And that applies to a significant number of the witnesses on the list. In our submission, it's a clear example that the protocol cannot and should not be applied to every witness.
If I may, Mr. Ellis, as you were talking about the proportionality principle, who appreciates basically the scope of the witness who should benefit from the protocol according to you? Should we duplicate the list of witnesses who have already been granted a protective measure, or do you think there should be another assessment basically based on the application of the principle of proportionality? And if so, would it be on an individual basis, meaning that for each witness there should be a new appreciation by the competent panel? Is it what you would envisage?
Your Honour, thinking practically, I can only see two ways to do it. One is for the prosecution or perhaps victims' counsel to make a new application for what's effectively protective measures for those witnesses where there is a justifiable need. The only other approach that I can see is perhaps the one that Agenda Item 2 hinted at, which is to try and find a way of dividing the witnesses into categories. And that was, I think, I hope I've understood it, this is the submission made by Mr. Emerson for Mr. Vesely, that one such obvious category might be victim witnesses. But those are the only two ways that I can see. And of the two, my preference would be for a new application to be made for specific witnesses based on their specific circumstances. Building on the work that's already been done, I suspect that's less onerous than it may initially appear. The other example I was going to give, Your Honour, of witnesses who should not benefit from a protocol would be those witnesses, including those witnesses drawn from former members of the KLA, including those people who have previously given evidence in public on multiple occasions, those witnesses who have expressed no concerns about their identity being known to the defence and indeed whose identity we've had for many months, those witnesses who the prosecution has interviewed as suspects. There are witnesses on the list, of course, who the prosecution summons as suspects, who attended with their own counsel and who declined to answer the prosecution's questions in exercise of their rights. If such witnesses are agreeable to and consent to meeting with the defence, why should the prosecution sit in on that interview? Plainly, their presence would have a chilling effect. And I did choose those words carefully when I said if those witnesses agree to talk to the defence, because it bears emphasising that all of our work here is based on consent. I have no power to compel a witness to meet with me if they don't want to. If they do meet with me, I have no power to force them to answer questions. So the work of the defence is inevitably based on consent. And I do, in relation to the victim witnesses, agree with the submission that's been made that where witnesses are represented by counsel, Article 16 of the Code of Conduct would come into play, and contact must therefore be made as a matter of courtesy, but also as a matter of obligation under the Code of Conduct with Mr. Laws before that contact can take place. That's of course subject to the practical point that we would need to know who the victim witnesses are, who he represents, in order to facilitate that conduct, that contact. I am concerned about the submission made in the prosecution's adjusted proposal that the prosecution must always be present at an interview with one of the witnesses on its list, whether or not that witness actually wants them there. The logic of the submission in filing 693 seems to be that because there may be some witnesses who would feel compelled to accede to an interview without the prosecution present, it follows that the prosecution must be present for all interviews. But what about those witnesses who, when they say they're happy to be interviewed without the prosecution present, mean just that? They want the interview to take place without the prosecution present. Ought not the protocol to provide for that? Your Honour, that's what I propose to say on agenda item 2. I believe agenda item 3, with an apology for jumping around, is with Mr. Baishu.
Thank you, Mr. Ellis. Mr. Bayesu, please.
We fully support, on this agenda item about the fair trial rights, we fully support the submissions of the previous speakers on these issues. Requiring the SPO to attend all interviews with the SPO witnesses is nothing less than a shortcut for the SPO granting, for the SPO being granted access to the defense lines of inquiry, documents, potentially incriminating evidence that the SPO would not normally have access to or have access to until later in the proceedings. And as it was said today, the disclosure obligations in the rules are asymmetric. Defense have a right not to disclose inculpatory evidence. The defense do, by Rule 104, paragraph 5, have to disclose the documents to the SPO no later than 15 days prior to the opening of the defense case, and then only if they are intended to rely on this trial. On the next question on agenda item 4, the Krasniqi defense are open to the idea of joint interviews. However, there are likely to be differing investigative priorities and interests among the defense teams, which means that the number of joint interviews is likely to be relatively limited. I'm going to jump to agenda item 6, and later my colleagues will make the submissions on the other agenda items to avoid switching between speakers. On agenda item 6, on the adjusted proposal, our fundamental objection to the SPO proposed protocol is not addressed in any way by the adjusted proposals. The core problem with the proposed protocol is that it applies in a blanket way to all the witnesses on the SPO list, without any distinction between those who actually need to be protected and those who do not, and without requiring the SPO to show that a particular witness needs and desires protection. Until that fundamental issue is addressed, any drafting changes will be insufficient to protect the fair rights of the accused. Finally, we disagree strongly with the SPO revised approach, which demands its presence in all interviews, even if the witness does not want them to be there. If a witness has something they wish to share with the defense and they do not want the SPO to be there, then the SPO presence has a chilling effect on the investigation, on the witness himself, but also on the investigation. Suppose a witness wants to talk to the defense about the manner in which the SPO conducted the interview or prepared the statements, and it's obvious that the witness will not talk freely in the presence of the SPO. I think now I will, with your permission, I will let Mr. Ellis to cover the other agenda points over which I jumped.
Thank you, Mr. Bayesu. Mr. Ellis, please. And I think we're close to the 15 minutes, so quickly. Thank you.
In that case, Your Honour, I will pass swiftly over agenda item 5, which I think was directed primarily
Mr. Ellis,
to the
we
registry.
We have an issue with your connection.
And move to number 7.
Sorry, we have an issue with your connection, so if you could repeat what you just said, and hopefully the connection will be a bit better.
I apologize, Your Honour. Is it clear now?
Unfortunately, it's not clear, so I suggest that if you don't mind, you just switch on your microphone and not the video, because that might help.
Are you able to hear?
Unfortunately, we don't hear you now, and I think the image is frozen on Zoom.
Try to turn the video off. Are you able to hear me?
Now I think we're able to hear you.
Your Honour, I apologise for the issue. I was merely beginning by saying that agenda item 5 is primarily directed to the registry and therefore one that I can pass over quickly. I did wish to say something about agenda item 7, though, in the time that I have left.
Please proceed.
Thank you, Your Honour. Your Honour, our position is in general that there is a danger in applying models derived from other courts directly to the KSC, since inevitably different courts have their own standpoint based on their own statutes, their own rules, and the circumstances of the cases before them. In particular, in relation to the ICC, Of course, its statute and its rules are materially different from those before the KSC. The ICC, by its nature, has to be able to operate in all countries, at times regardless of whether that country is cooperating with the court or not, and at times regardless of whether the conflict is ongoing in that situation or not. The KSC operates primarily with regard to Kosovo, is established within the legal system of Kosovo, so that it benefits from the enforcement powers, for example, of the Kosovo police, and it's concerned with a conflict that ended some 20 years ago. It's also worth noting that the size of this case distinguishes it from anything that the ICC has previously tackled. The case of Bemba, for instance, concerned around 42 prosecution witnesses who gave oral evidence. Bagbo, 82 prosecution witnesses giving oral evidence, but none of these have had to address a case with 265 witnesses expected to give oral evidence. And that must sound in the practicality of applying a protocol, because a procedure that works for 80 witnesses with 2 accused is not necessarily going to work with 3 times as many witnesses and 4 accused. The practice of other tribunals is not identical on this issue. So far as I'm aware, there was no prescriptive protocol of this time at the Special Tribunal for Lebanon. At the ICTY, which of course is the closest to the jurisdiction of the KSC in terms of the temporal and geographical scope, the jurisprudence of that court, including the cases that the prosecution has cited, was by and large to recognize a general right to interview the witnesses of another party, but to preserve the possibility for the calling party to seek protective measures if they were needed. And note an example of that might be the Karadzic decision of the 8th of November 2012, which I know will be well known to the prosecution because Mr. Tiga was counsel for the prosecution in that case. The decision concerned the interview of defense witnesses. The prosecution's position in that case was that there was no proprietary interest in a witness, and so it should be able to interview the witnesses. And the court strongly endorsed that the parties were free to contact witnesses of another party. And that, in my submission, is exactly what we're proposing here. That there should be a general right to interview the witnesses of another party, subject, of course, to the possibility to seek protective measures where they are needed, and where, in accordance with the regime for protective measures, those measures can objectively be shown to be justified. I think that leaves item 8, Your Honour. We will gladly enter into inter partes discussions, although if the prosecution's position remains that the protocol must apply to all witnesses, it may be that the discussions don't get very far.
Thank you, Mr. Ellis. Let me now move to the registry. Mr. Nielsen, if you can address the various questions in the scaling order, and also if you want to update your previous submissions after the latest SPO response, especially on the impact for the registry on the budget and the organization. Mr. Nielsen, you have the floor.
Yes, thank you, Your Honor. Yes, I was going to focus on question 5 and 6, which is directed to the registry. In fact, we have no submissions on the other questions. Starting with the 5th question, which concerns whether the registry can provide more specific information on the ramification of its proposed involvement in light of responses given to the submissions. With regard to this question, I'm leaving aside the updated or the revised protocol proposed by the prosecution. I'll come back to that. So we have indeed received some indications from at least some of the defense teams with regard to the number of witnesses to be interviewed. We've also received certain indications with regard to other questions indicated in our filing. So these questions concerning the number of interviews, where the interviews will take place, length of interviews and so on. With regard to these questions, the defense has not been able to provide that much specificity, and that's, I would say, understandable. It's difficult to answer this question in abstract. We are nevertheless grateful for the indication, because they have made it a little bit more concrete on what we are dealing with here, both for us and I think for you as well, Your Honor. What I can say from the perspective of the registry, we are in need of fairly precise information in order to properly plan for these interviews and to manage the existing resources, but also to seek additional resources if that should be needed. And we unfortunately do not have that precise information right now. Therefore, should the registry be instructed to assist in the manner foreseen in the original protocol, we would have to get together with the parties and discuss and consult on how that best can be carried out. And from there we would create a plan like we would do any mission plan. And I think it's only in that concrete context that this feasibility assessment could be made. And where the question is not so much whether we can assist, but more how we can assist. So I think that's unfortunately as far as I can go with the information we have before us today. Moving to question 6. So here we note that the revised proposal foresee a much more limited role of the registry. Essentially, the revised protocol describes an arrangement according to which the registry might be involved in some interviews in exceptional circumstances and only after a decision by yourself or by a panel. And I would say that the exact scope and role of the registry in those circumstances that would then be the subject of a request by the calling party or by a party, and then ultimately a decision. Very short, in such an arrangement as foreseen in the revised protocol, that could and certainly would be accommodated by the registry. I think the only thing we would ask to consider in that respect is to provide for a proper period of notice to be built into such an arrangement to ensure that we would be in a position to provide effective and timely services. I think that's as far as I can go with that question. With regard to maybe the last question that you have asked, I'm not sure whether we are in a situation where we would be instructed parties to have inter-parties discussions. Should that happen, the registry of course stands ready to participate or at least be available for consultations if that should be needed, acknowledging that there might be a limited role for us in that context. Thank you.
Thank you, Mr. Nielsen. Let me now turn to the prosecution. Do you wish?
Your Honor, just before the prosecutor responds, would you hear from me just for 2 minutes?
I will first give the floor to the prosecution, and then I will do another round, and you will be able to present your views then. Mr. Prosecutor, please. And again, only on what has been said by the defense, no new argument. We are wrapping up now.
Thank you, Your Honor. First, two brief legal points in response to the defense. Article 21(3) of the Rome Statute requires that the interpretation and application of all ICC law be consistent with internationally recognized human rights, and thus suggesting that the ICC and the right to a fair trial are two separate worlds is inaccurate. Second, claims that disclosure of witness defense statements would violate any aspect of the right to a fair trial have been consistently rejected since the Thaci appeal judgment of 15 July 1999, and I refer to paragraphs 323 to 327. Then a more elaborate point. Several defense teams have made submissions that there is supposedly no climate of intimidation in Kosovo, and nothing could be further from the truth. There has been significant evidence offered on this specific point in connection with detention. There is a history of cases in Kosovo and at the ICTY where this occurred, and this court has been established with this well-known history in mind. In fact, the situation is so grave that the SPO has been unable to obtain the cooperation of an international expert and other international witnesses, expressly because of security concerns connected to that climate in Kosovo. And those are international witnesses. We have previously provided the court specific examples of such security concerns and intimidation felt by international witnesses. I refer to filing F5, Annex 1, paragraphs 6 and 7. And for many of the other international witnesses, the SPO itself has had to adhere to strict clearances and other requirements in order to be able to speak to the witnesses at all. For witnesses in Kosovo, those concerns apply much stronger. There is a reality of rules and regulations in this courtroom, and there is also a reality in Kosovo. And that reality is one of enormous pressure for witnesses who have no real choice when they are approached by the defense and are asked to agree to what the defense wants. And the Thaci defense team is actively fostering this climate by publicly claiming that this is a case against the KLA. They know that is not true. The SPO has pointed out before that there are no cases against the KLA before this court. The Thaci defense deliberately continues to distort the truth about the nature of this case to increase pressure on witnesses, and it openly emphasizes that it is planning to keep doing exactly that. Now let's be clear. The proposed protocol is not meant to solely guard against misconduct on the part of the defense. The protocol aims to provide at least a degree of protection to all parties in their interactions and to protect the integrity of the evidence and the expeditiousness of the proceedings. But we also need to acknowledge reality here. We see that reality in Kosovo, and we see it in this courtroom. And part of that reality, for example, is the publication in Bota Sot on the 3rd of November 2021. And that report includes that several former members of Kosovar intelligence services are now rendering their services to the Thaci defense team. And one of the men named in that coverage is a former KIA official who is currently being prosecuted in Kosovo for abuse of office, and he is also accused in the press of being involved both in KIA attempts to obtain confidential information from the Kosovo President's Office and of organizing false witness testimony by KIA agents in a trial in Kosovo. Obviously, we do not know the full story behind this reporting. The SPO does not know who is working directly or indirectly for the Thaci team. We do know that the Code of Conduct only applies to counsel and not to their team more generally, so that code is not helpful when it comes to individuals engaged as investigators by the defense. And we do know that this court can't afford to ignore the past and the very real and specific information in the present, but needs to act on it. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Before I give the floor to the defense, let me just ask Mr. Laws. Mr. Laws, do you have anything you would like to add? And maybe just one follow-up question on my side is, do you have any position on the updated SPO proposal that proposed that the registry has a more limited role compared to the initial proposal? Thank you.
Your Honor, I thought I had dealt with that in my submissions earlier today, but if I didn't, then may I say no, we don't have any objection to the more limited role for the registry, subject to, as we suggested, certain exceptional circumstances. Just very briefly this, Your Honor. The ICC protocol plainly takes what might be called a broad brush approach. It applies its rules to all the witnesses And the reason for that is that there are, as the SPO we respectfully submit have properly stressed, a number of different factors making up that protocol that commend it as a sensible way to manage large numbers of witnesses or small numbers of witnesses. For example, the fact that it's got to be video recorded. So it's sensible for there to be a solution that accommodates all the different categories of witnesses. And when we look at the alternative, we can see why the ICC would want to stick with their protocol and apply it equally to all comers. What we're going to end up with in the alternative, as proposed by Mr. Ellis, for example, is eventually 150 written applications justifying each individual time that a request is made for an interview, justifying the presence of the SPO or justifying the video recording. That will never end. That will be a recipe for utter stagnation, because it'll be 150 applications followed by 150 responses, 150 replies, 150 rulings, 150 appeals, and we'll get to a stage where we've heard just little whispers of it already, where evidence will need to be called to substantiate what's being said about each individual. This is, we respectfully submit, a path which is going to lead to difficulty. I'm not going to put it any higher than that. And we, on behalf of the participating victims, do have an interest in witnesses beyond those that we directly represent, and I confined myself to a specific part of the agenda for today earlier when I said, made the remark that Mr. Emerson alighted upon. We do have an interest on behalf of the victims in relation to the viability of these proceedings, because the participating victims have an interest in the proceedings as a whole, and we respectfully submit that what we're looking at here is a proposal that's coming, which is going to end in these proceedings being non-viable.
Thank you, Mr. Laws. Mr. Kihu, please.
Yes, Your Honor. Just briefly, and I might, if time permitting, just one last comment from Mr. Misicic if need be. I trust Your Honor sees what the prosecution is trying to do with elevating some type of climate of intimidation that he's talking about with no proof. They did the same thing with the Kosovo police when we came to the detention application. They put forth a litany of what I can only describe as nonsense without standing behind it or showing it to the light of day concerning that. They're doing the same thing here. And they're asking this court to give them what they want because they're saying, oh, there is some climate of intimidation. Who has been intimidated? They have 326 witnesses. They have 157 protected witnesses. Who of the 157 protected witnesses have been intimidated? And how about the rest whose names have been listed that, frankly, Mr. McCluskey has been interviewing? Have they been intimidated? Is there any proof whatsoever? But they expect you to cave to this nonsense by just putting it before Your Honor as if to say, oh, I'm going to tell you about this parade of horribles. You have to give us what we want, and we have to appear before in every interview. Even with their adjustments, the one thing that they say is, we have to appear before every interview conducted by the defense, and the witness can't waive it. It's a remarkable sleight of hand that is put forth under the guise of there is this climate of intimidation. Some international expert was somehow couldn't be retained by the SPO in order to present evidence? Was he threatened? Was he somehow advised not to do it, or would personal harm would come to either him or some loved one? Of course not. The problem, Judge, is that what they're putting before Your Honor is this climate of fear for their own purposes to the detriment of my client and the other accused, who are entitled to talk to these witnesses and are entitled to talk to these witnesses outside the presence of the SPO, who, trust me, Judge, will bring their own fear and intimidation. Take example, the individual who was called and told he was going to be a suspect, and he hasn't been indicted, but he was advised he was going to be he was a suspect. And mind you, Judge, there are scores of such witnesses. Were they intimidated by the prosecution? Of course they were. They didn't want to get charged. They didn't want to get indicted. Was the defense part of any of those interviews? Are we asked to come in for these suspect interviews? Of course not. Were we invited in for any of these witnesses? No. And this whole idea advanced by the prosecution that these witnesses have no choice. I read a transcript yesterday, where a witness, and I can tell you who the witness was in closed session if need be, where the witness refused to testify and invoked his rights. Why wasn't that person intimidated? Why wasn't that person so taken by this climate of intimidation that he spoke he spoke to the prosecution? He invoked his rights against self-incrimination. Mind you, he was brought in for a suspect interview. So as far as no real choice, the prosecution should go through their hundreds of witnesses, not only the ones they've listed, but the ones they haven't turned over to us, and set forth all of those witnesses who, for whatever reason, declined to testify, declined to give a statement on matters that have nothing to do with President Thaci and the accused. They are trying to instill this court with fear based on nothing. This indictment has been pending since November of 2020, and the prosecution has come forth with no witness in their hundreds of witnesses that have been intimidated. Certainly, he cannot cast any specter on anybody in this room. Nevertheless, they reach down and throw the fear card before the court and say, you have to engage in this, Judge, and they want to do it to the detriment of the rights of these accused. Other courts have come up with protocols like this, Judge. Nothing remotely comes close to this. Nothing remotely comes close to a situation where an interview is conducted in the presence of the SPO, it is taped, and then they get to use that in evidence in their case in chief. How that is not a violation of Rule 1045, it's difficult to fathom. We can talk about other protocols, ICC, ICTY, ICR, etc. But we have to be guided by the rules that the KSC has put before us. And 1045 is the rule that we have to follow. So under the entire, engulfing the entire scope of what the prosecution wants to do is, as I started, they want control. They want control of how the defense does their investigation. They want control on who says what and asks what to witnesses. They want to know about exculpatory information coming from these witnesses that the defense has the authority to develop. They want control of all of that. Let's keep in mind that they have 157 protected witnesses and 103 anonymous witnesses. In order to take control of this entire proceeding away from Your Honor. Now, putting aside what they have put on the table, let us talk about the practicalities of what they're saying. They have 326 witnesses. I just heard from Mr. Ellis that he heard the number of 265 being called. I would tell you, Judge, that the interviews of those individuals, of those remaining witnesses, were be in excess of 100. I don't know where it's going to be between 100 and 200. I can't tell you at this point, Judge, and with all due respect. But it's over 100 witnesses. 100 witnesses to coordinate and bring before and under the regime that they have to be filmed, and the SPO is there and getting all of these schedules together. This trial is not going to be tried in 2022, 2023, or 2024. The pure undertaking of what the SPO has put on the table is completely unmanageable. And nobody, certainly not the SPO, has infused that consideration into what they're proposing that this court should set forth in a protocol. Now, as my colleagues have mentioned, if a particular witness is a particular frail person that is significantly damaged emotionally and mentally, again, nobody in this court is interested in damaging anybody. They want to do what's necessary to protect their respective clients, but they don't want to bring harm, ill will, and any suffering upon anybody else. But again, as my colleagues have mentioned, there has to be a balance. Who are those witnesses? Tell us who those witnesses are. Tell us what the particular problem is, and we can work with that problem. But we don't have that. What we have is a broad blanket, every witness, I mean, including retired diplomats in a variety of countries.
Please conclude, Mr. Kehoe. You've
Yes, Your Honor.
explained
So
that
suffice
several
it to
times
say-
today.
Yes, without this, suffice it to say, the issue of time is a significant one. And if Mr. Misicic just briefly comment, and we'll finish. Thank you.
Thank you, Mr. Kehoe. Very briefly, Mr. Misicic, you have 1 minute.
Do my best. Mr. President, let me just briefly respond to the prosecution. You have not heard a response to our submission that for 13 months, they allowed all defenses to contact their witnesses without any protocol being requested. So the issue comes up, if there's such threat from the defense counsel, why did they stay quiet for 13 months? We raised it in our written pleadings. We raised it in our submissions this morning. They stay quiet because I think the facts are what they are. We've mentioned this morning, we are accredited counsel through a vigorous process. None of us have, as far as I know, with respect to any defense team, any prior verifiable interference with witnesses or tampering with evidence, anything of that sort. And there's been nothing since we've been accredited in the case. No allegation by the prosecution that any witness has come forward with any complaint about contact from the defense. So we have that factual record. And in response now, in rebuttal, for the first time, I would say improperly, there's an allegation made directly that the Thaci defense is first putting pressure on witnesses and is saying that it will continue to do so. You can read our submission, and I'm sure you have, Your Honor. We've made no such claim. As a matter of fact, we've said consistently the contrary. I'm surprised that the prosecutor is not familiar with the Code of Professional Conduct, because you were made a submission now that the Code of Professional Conduct only applies to counsel. And I would just refer you to Article 34 of the Code of Professional Conduct, which imposes supervisory liability on counsel and co-counsel for all those over whom they have direct supervision. There's a, to my frankly shock, the prosecutor comes into court in the last submission to quote what is apparently a tabloid in Kosovo, to say that some person is working for the Thaci defense, raised for the first time, not in written submissions, not in first submissions, but in the last round, and then concludes by saying the SPO, of course, doesn't know whether any of this is true. We leave it to you to assess, and we think it should reflect on the credibility of counsel to make such claims, which are very serious allegations, and then say we have no ability to actually verify whether anything we've said is true. We submit to you, Your Honor, it's not true. And I'm frankly shocked by how the submissions have regressed to this point. Finally, the last point, and I think the most substantive point here, is going again to the European Convention. It is not our position that we are calling into question other judicial systems in other European countries. Our point is that in a system such as this, where there is an adversarial system, where the defense was not allowed to participate in the investigative stage, where other systems would allow the defense to participate, particularly Kosovo, which is the system we're in, we would have been under the Code of Criminal Procedure allowed to participate in the investigative phase. We weren't. It was to our exclusion. We're now in a different system. And in this system, we would again rely on the European Convention to say we should also have the right to investigate without, which we didn't have in the pretrial phase, in the investigative phase. We should have the right to investigate without having to potentially sacrifice the right against self-incrimination. And on this point, and we'd be happy to brief it further on the implications for the European Convention, let me just direct your attention to one case of the ECHR, which is the case of Saunders versus the United Kingdom. It says the right not to incriminate oneself in particular presupposes that the prosecution in a criminal case seek to prove their case against the accused without resort to evidence obtained through methods of coercion or oppression in defiance of the will of the accused. And this is a right that is closely linked to the presumption of innocence contained in Article 6, paragraph 2. So we would rely on that and other cases if you want additional written submissions on this point. And with respect to the issue of whether the KLA is implicated or not, we leave it to you, but we would just direct you to paragraph 35 of the indictment and let you draw your own conclusions on whether our positions are unreasonable on this point. Thank you, Your Honor.
Thank you, Mr. Misitic. Mr. Emerson, please.
Your Honor, can I deal with that first point first of all? As I'm sure Your Honor will appreciate, and in my case, as one speaking as counsel who's litigated in front of the ECHR probably more than any other over the years, the ECHR views each case individually. They doesn't make categorical statements about what is and isn't fair in general terms. It may be an adversarial process, it may be an inquisitorial process, but the court will look in granular detail at how that process is applied in the individual case. So you can have a situation where there is an infringement to some extent of the rights of the defense, but it's kept as narrow as possible and is safeguarded by alternative safeguards. And in those circumstances, what might appear to be the start of an unfair process can become fair by the way in which it's managed. In other words, putting it bluntly, there's a world of difference between an excessive interference into the rights of the defense and one which is proportionate. And like Mr. Laws, we are deeply concerned about the viability of these proceedings at all if this protocol is adopted as it has been presented. It is impossible for the case to be ready at a reasonable time if that additional liability is imposed. And in practical terms, that directly impacts our client, because the longer the pre-trial period is required to take, they are in custody for the purposes of this, and we have to assume they will remain in custody. So this is all a process which, if applied excessively and indiscriminately, as the prosecution asks you to, will have the direct effect of prolonging their pre-trial incarceration as men presumed innocent by at least a year. I mean, that's a rough estimate, but it's obvious. So that's a good start for why we need to look for a proportionate response. And I wanted, having heard the submissions of all parties, to make a proposal for your consideration. It seems, with respect to those who perhaps disagree on the defence side, that if you have a witness who is protected by your order and those protections remain in place, in other words, we're not past the 30-day pre-trial or the 30-day pre-testimony situation, then it seems to me, and I don't wish to be categorical, but this is how it seems to me, that those individuals ought to be subject or could be subject to the protocol's requirements without infringing the rights of the accused, because the rights of the accused are already to some extent restricted in relation to those witnesses. And one has to assume this, I don't know whether it's true or not, perhaps the prosecution could confirm, that those witnesses, when asked, indicated that they wanted this protection. In other words, it wasn't just the prosecution making decisions for them, it was an application made after, if not a request, then at least an agreement from the witness. If not, then we have a real problem. But assuming that's the case, then those witnesses, it seems to me, it would be very difficult to interview them while those protective measures were in place without infringing the protective measures, to put it bluntly, because one wouldn't know what questions one could legitimately ask and what questions one couldn't. And in the end, then the prosecution would be the referee of the conversation that was taking place. And that can't be right. So it seems to me that the protection could apply in those circumstances without significantly interfering. The second category is victim witnesses who are not the subject of protective measures. So these are people who have not requested any protection for their identity. Now, it seems to me that that category could be dealt with by notification to Mr. Laws, because he represents them all, and by a guarantee that all interviews are conducted by counsel subject to the Code of Conduct rather than by investigators, as well as a requirement on counsel to explain to the person to be interviewed that they have the right to discuss their situation with Mr. Laws, and he has the right to make representations to the tribunal if he thinks, on discussing it with the individual person concerned, who after all hasn't requested protective measures up to now, that it's necessary. It's difficult to see why it would be necessary if a witness is not sought protective measures. But you know, contrary to what Mr. Laws says is that will result in 150 applications that he's got to draft, that's not so, because in reality, if a witness hasn't asked for protective measures, it will be the exceptional circumstances in which it's appropriate to enforce the protocol, because there would have to be something that's changed since the time that the protective measures discussion took place with them. As for all other witnesses, it's simply no justification for applying the protocol to them. On the other hand, it does seem appropriate that counsel conducting the interview should explain to them that if the witness objects or has concerns, they are entitled to contact the prosecution, at which point, if justified, having discussed it with the witness, the prosecution will make a suitable application for the matter to be dealt with under the protocol. So you have there what arguably would be considered a proportionate and staged approach, which enables the core of the defence rights to remain intact. It's not excessive, overbroad and categorical for every witness, which is ridiculous and obviously can't be justified. And it focuses core attention on the witnesses we know have concerns, applying it automatically to those witnesses, and it enables it to be applied by application of Mr. Laws or the prosecution if having notified the witness of the right concerned, to consult the person, Mr. Laws or the prosecution. After all, Mr. Laws will already know that the witness has been contacted and may well have spoken to them before we do. It should be clear. It may well be that some of Mr. Laws' witnesses have absolutely no objection whatsoever to being interviewed by the defence. They may well want to be. It's simply a question of how the situation is put in a proportionate way. So that's my first.
Mr. Emerson, your microphone is off.
I don't know how that happened. The second submission relates brief, and these are brief submissions, to the suggestion of there being an atmosphere of intimidation in Kosovo. I'm not going to dispute at all that there have been numerous instances in which in Kosovo where witnesses were either intimidated or didn't give evidence, or for one reason or another failed to testify or testify in accordance with their statements. Almost all of them go back to the immediate post-war period or the years following. And it's absurd to suggest that the passage of time since the conflict is irrelevant. Kosovo has moved on, it's governed by a new political party, and the situation is not one where there is where one can simply transpose what happened in 2006 to what is happening on the ground now. That's the first point. The second point is that there were numerous witnesses, for example, in the Haradinaj trial, which was cited by the prosecution, who were called and gave a different account. But that's because there were numerous witnesses who admitted that they had given a false account in their refugee claim when they claimed, for example, refugee status in another European state. And that they had been held to that up until trial. In other words, they were telling lies in order to get refugee status, and then were not in a position where they wanted to repeat those lies on oath in a court. And there were a number of witnesses who were reluctant and gave evidence, and turned out to be people who had been put up to saying what they had said by the Serbian intelligence services. In other words, their first contact with law enforcement had been with Serbian intelligence services, and they had given false accounts in that process. There were numerous witnesses who get that, one of whom indeed admitted in his testimony that he had been asked to come and lie to the ICTY in a very serious matter.
Mr. Emerson, please conclude, because we have 10 minutes left for all the defense teams, please.
Yeah, that's fine. I will conclude on that. I'm just trying to say that's a much more nuanced position than is being presented to you by the prosecution. And the two witnesses that were referred to in the Haradinaj appeal chamber's judgments as not having testified did testify at the retrial, and of course all accused were entirely acquitted. So, or apart from one who got a minor conviction, but not relating to that witness's evidence, either of those witnesses' evidence. So that's the position in relation to witness intimidation. I want to touch on the criticism of Mr. Thaci's counsel, and also of me, for suggesting that in public that this is a case directed against the KLA rather than against these four accused. And I'm not going to say very much about it, other than to say this. The case against Mr. Vasili does, as the prosecution has accepted in its pre-trial brief, depend essentially on the fact that he was part of the KLA leadership dealing with intelligence. There's no other evidence against it. There's no involvement in any specific crime, as the prosecution has acknowledged. They're simply trying to say that because of the role that he had, he must be responsible for everything that was done by anyone wearing a KLA uniform at any time in any case in Kosovo between the beginning of the relevant indictment period and the end. Now, that is saying we are attacking the KLA as a joint criminal enterprise, and this man as
Point of order, Your Honor.
Please, Mr. Prosecutor, I'll give you the floor, but Mr. Emerson, please conclude, like in the next 20 seconds.
Yes. Last point, then. Mr. Counsel for the prosecution seems to backpedal to some extent on his reliance on the risk of defence counsel committing a crime in conducting interviews. He seemed to backpedal on that a little bit. That submission, Your Honour, was unprofessional, professionally immature, and undermines the credibility of not only counsel, but the prosecution as a whole. The whole charade was nonsense. I would ask him to formally withdraw that outrageous and defamatory allegation and to apologise for it, failing which we'll consider whether to make a complaint about his conduct.
Mr. Prosecutor, very briefly and only on what has just been said, because we need to wrap up, and I still need to give the floor to two defense teams, and we have 9 minutes.
Yes, Your Honor. Counsel has just mischaracterized both the Haradinaj case and the indictment and pre-trial brief of the SPO. It's unprofessional, it is dishonest, and he should stop doing it. Everybody can read those judgments, everybody can read the indictment and the pre-trial brief, and there's no use trying to change up and down and down and up. It's simply dishonest and it needs to stop. Thank you.
Elise.
Mr. Tully, please.
Thank you, Your Honour. Very briefly, we didn't hear anything in the response from the prosecution which contradicted our submissions. We would note that if the information contained in the response is indeed accurate, that there are witnesses who face a risk, we simply go back to our same submissions, that Rule 80 has parameters, they must be met, and identify the witnesses at risk on a case-by-case basis, show us the circumstances of the risk, indicate them with specificity, that objectively justify those measures, and if it is decided that measures should be imposed, then the least restrictive measures should be applied to negate that specific risk. That's all, Your Honour. Thank you.
Thank you, Mr. Tully. Mr. Bayezou, please.
With your permission, Mr. Ellis is going to respond.
Thanks, Mr. Bayezou. Mr. Ellis, please.
Thank you, Your Honour. I see the videos holding up for the time being, but I'll be brief in any event. Just 2 points, Your Honour. The first is this. We asked for a justification for imposing a protocol on international witnesses. As I heard the response from the prosecution, it was to look at filing 5, Annex 1, paragraphs 5, 6, and 7. Well, I've done that. Paragraphs 5 and 6 are general assertions of the type we've heard orally today. Paragraph 7 relates to one specific international witness who appears to be somebody at a junior level as compared to the senior military officers and diplomats referred to in the defense submissions, and appears to be an individual who had family ties to Kosovo. That is clearly not a good source of evidence justifying imposing a protocol on all the international witnesses in this case. Secondly, coming back to Mr. Laws's submission, no, of course, I'm not asking for 150 separate applications to be made. That's not the way protective measures have worked in this case. We've got some 100 witnesses still subject to delayed disclosure. We didn't have 100 applications made individually for each of them. If Your Honour is with me that this is a question of protective measures, then the prosecution and indeed Victims' Counsel could be given a time limit to make one compendium application dealing with those witnesses who actually need the protection of a protocol. If Your Honour thinks even that would be disproportionately intensive, then I commend the nuanced position that Mr. Emerson advanced in relation to categorising witnesses. But what I do emphasise should be avoided is just imposing a one-size-fits-all approach, a protocol on all witnesses, when that clearly is not justified.
Thank you, Mr. Ellis. This concludes today's hearing. I thank the parties and participants for their attendance today, and I remind everyone that the next status conference has been scheduled for Thursday, 24 March at 14:30 Hague time. I also wish to thank the interpreters, as usual, stenographer, security personnel, and audiovisual technicians for their assistance. The hearing is adjourned.
All rise.